Philip D. Hart, Wesley Gossett, Rosa Hamrick, Donald Porter, Adrian Waldron Bishop.
Angela DeHart is 23,681. She's been at Bethesda. Okay, it's a good report. Looks like there's still things that are being worked on. You just have court costs to pay.
Okay.
Can you pay anything on your court costs?
Not at the moment, but I will be able to soon.
Okay. Okay, I'm going to set your next hearing. Does it matter if it's Mondays or Fridays?
It does not.
April 15th, that's a Monday.
Thank you, Your Honor.
9 a.m., April 15th.
Thank you.
Wesley Gossett, 21,729. Okay, he's failed to appear. He has just a warrant fee to pay is off left, so be a warrant issue for failure to appear and pay it off. Rosa Hamrick is 24,500. I got the report, copy of it emailed to me. Now we got a physical copy.
She's compliant.
It's a good report. You also has some fines and community service to do. So how are we going to take care of that?
Yes, here soon I'll be able to take care of it.
Okay. You got 5 days community service and some fines to pay. So those need to be taken care of too, but you're doing well on your counseling, so keep that up. I'll set your next hearing for April 29th,
Thank you.
9 o'clock. April
Thank you,
29th.
Your Honor.
Donald Porter is here.
Yeah.
You just have some fines to pay. Do you have anything to pay?
I just spent all my money getting my license back a week and a half ago, so this Friday I get paid, I can pay 40 or 50.
This Friday?
Yeah, I can pay them this Friday, so I'll come in and pay. And Mondays is my only day to try to do community service in Irons, so can we schedule a Friday, please?
I'll set your next hearing for April 12th,
Thank you.
9 o'clock. Adrian Waldron Bishop.
She completed, Your Honor.
Okay. Okay, got a letter of completion for her, and she did pay her obligations off, so her case will be marked completed.
Thank you.
Thank you. Okay, that finishes the reviews. We're going to start with new cases now, so anyone's in the lobby that's got a new case, an arraignment, they need to come in. We're going to start those now. So if you're here for an arraignment, your name will be called. So this could be a new case, or if you missed a hearing on an old case, will be called with the arraignments. If you don't get called and you think you should have been, go check in with the clerk and tell them you're here, and then I'll put you on the docket. If you missed something before, we won't know you're here, and you won't be on the docket until you go check in. You have a right to remain silent. You don't have to say anything. If you choose to make statements, what you're saying is all being recorded. It can be used against you if you admit something about your case. The state can use it against you if they wish. So Wes said sometimes the better. You have a right to have an attorney, to have one appointed if you can't afford one. You have a right to bail and to make the state prove any charge against you beyond a reasonable doubt. Those are the rights all defendants have. If you enter a guilty plea or no contest plea, you're waiving those rights. You should not waive your rights if you don't understand what's happening, if you're not sure what to do, or if you want to talk to a lawyer or have a trial on your case. Any of those reasons, you should enter a not guilty plea when you're asked for a plea. Don't enter a guilty plea just because I want to get it over with. That's not a good reason to plead guilty. Call the first case, please.
State of Ohio versus Melissa D. Calico, case number CRB 2477.
Ma'am, are you Melissa Calico?
Yes, sir.
And you received a copy of the charge?
Yes, sir.
Okay, the case number is 2477. It alleges that February the 8th of this year, you were the parent, guardian, or custodian of a minor child that you violated a duty of care, protection, or support for. So that's endangering children. It's a first-degree misdemeanor. Maximum penalty is 6 months in jail, $1,000 fine. Do you understand the charge?
Yes, Your Honor.
Do you understand the rights I explained to defendants?
Yes.
How do you wish to plead to this charge?
Not guilty.
Do you want a lawyer appointed to represent you?
Yes.
Do you have a job?
Yes.
What do you do?
I do home health.
Are you paid by the hour for that?
Yes.
How much per hour?
So like 14.
How many hours a week do you work?
About 40.
Okay. And apparently you have some children that you're supporting?
Yes, sir.
How many?
Well, my daughter's over 18, but so one.
Okay. You're eligible for court-appointed counsel. I'll
Okay.
appoint Mr. Steyer to represent you.
Thank you.
He's here, so we'll get him in the courtroom so you can meet him.
Okay.
I'm entering a not guilty plea for you.
Yes, sir.
Mr. Steyer, this is Melissa Calico. She has a endangering children charge filed against her. I've appointed you to represent her. Not guilty plea has been entered. So we need to set this for a pretrial. And I'm looking probably the 22nd or any time after that's okay. March 22nd or after.
Okay.
Is Monday or Friday better for you? Does it matter?
It does not matter.
Let's go with the 25th, Your Honor, please.
March 25th will be the pretrial, and that will be at 10 a.m.
Okay.
She can sign a $1,500 signature bond.
Okay. Thank you, Your Honor.
You're welcome.
State of Ohio versus Aaron B.
Okay,
Jacob,
I'll talk to you.
case number TRC 24472, A and B. Aaron Jacob.
Aaron Jacob. Aaron Bradley Jacob of South Point was cited to be here this morning at 9 a.m. It's after 9. He has not appeared. It's on an OBI from the State Highway Road Patrol. So there'll be a capias for his arrest issued to the OSP.
State of Ohio versus Heather Chin, case numbers TRD 201711 A and B, TRD 201761 A and B, TRD 2286 A and B.
All right, and you're Heather Chin. She's at Bethesda.
Yes, Your Honor.
this outpatient or inpatient?
It's inpatient.
Okay. You self-referred there? or- okay.
She, yes.
Okay, I think that's a good choice. So congratulations on making a good decision.
Thank you.
And I support it. So let's see, we'll come back in about a month and see how things are going. April 15th.
Thank you, Your Honor.
Okay.
Thank you, Your
I'll
Honor.
set it, if there was a warrant out,
There was.
I think there was, I'll cancel it. And our next hearing, which will be reviews, will be April 15th at 9 a.m.
And I can pay all my fines today.
Very good.
Okay.
Okay. See the clerk and we'll take whatever you want to pay on it.
Okay.
The main thing for me now is your sobriety. I want to make that the number one issue, so fines can wait, but sobriety's got to be number one. But if you want to pay something, we'll take it.
Okay. Thank you. Thank you,
You're
Your Honor.
welcome. Okay, well, it's all the arraignments we have for now. We're going to start into the pretrial item.
State of Ohio versus Timothy Adkins, case number TRC 23-1834, A and B.
This is Mr. DeWaters' case. It's set for pretrial today.
Judge, on this one, I need to speak to Mr. Atkins just for a moment. Could we call this up a little bit later? I'll
This case will be recalled later in the document.
thank you, Judge.
State of Ohio versus Samuel Julian, case number TRC 23-1598, A and B.
This is Mr. DeWaters' case set for pretrial.
Judge, discovery is now completed in this case. I talked to Mr. Heald about it a little bit this morning. At this point, we're not able to resolve it. There does appear to be, so there were the standard battery of field sobriety tests administered in this case. One of them, there were no clues, so that one we're not complaining about. The other two, though, I think Mr. Heald's suggestion is that we file a motion on the other two. There is no breath score. So that's what we intend to do. I expect it'll be a relatively brief motion and probably a short hearing.
Okay, when do you think you can have the motion filed?
I think I can have the motion filed by the end of this week.
And then come back for a pretrial on the motion, or you just want to set an evidentiary hearing?
We could have a pretrial on the motion, that'd be fine.
Okay, I'm setting hearings for March 22nd or after.
Is April 1st bad? I've got several on that day already, I know.
April 1st is a good date if you want to set it.
Okay.
Okay, April 1st will be the pretrial on motions to suppress.
Thank you, Judge.
You're welcome. That'll be at 10 o'clock.
State of Ohio versus Eric L. Ferris, case number TRC 23-1183.
This is Mr. DeWaters' case set for pretrial.
Judge, this one we had resolved at a prior hearing. The agreement was that the charge would be amended to a reckless driving charge. However, that was conditioned on Mr. Ferris completing a 72-hour driver intervention program. He brought me proof of that today. May I approach it?
Yes.
Miss Connie should have sent you paperwork to the courthouse as well.
Okay. So you went to the one in Portsmouth?
Yes, sir.
Okay.
So I think we're ready to resolve this case at this point.
All right, Mr. Heald, do you agree with that?
Yes, Your Honor, and we had discussed that at an earlier date, that there were some evidentiary issues that would lead us to the conclusion that that was a just outcome. If he did the school, we would agree to amend to a reckless operation.
All right, I'll allow the amendment.
That's the
That's
section
correct.
number that I have.
Yes, that is correct. And I'll change the points to 2. 1 and 2.
Thank you, Your Honor.
You're welcome. Anything you wish to say, Mr. Ferris?
Do I have a fine to pay? I can pay it today.
Well, yeah, I haven't assessed it yet.
All right.
I'm gonna assess it.
I'm just ready to get this over with. I don't
You have a
want-
right, it's a fancy word, it's called allocution. You have a right to say something to the court if you want to before your sentence. You don't have to, but that's the procedure. You want to say anything? All right.
Listen, Your Honor, he had no insurance at the time.
But no, I just got picked up the car because it had been worked on. I just bought the car. No. Okay. I mean,
Judge, he,
Did you just bought the car, or?
I just got the car. The tag and the insurance was still on the car from the previous owner. He did not pull it off at the time.
Well, you've got a grace period usually with your own insurance company to have insurance placed. Here's the problem.
Yes.
In Ohio,
I had it.
the BMV will, I'm not gonna suspend you, but once this gets processed to the BMV, if it comes in as no insurance, they're gonna suspend you from carrying without insurance, so we gotta take care of that.
Well, I had South Carolina insurance because I just previously moved back.
It doesn't matter as long as it was insured, but you're kind of in a gray area there since you just bought the car, but you're gonna have to show that there was some kind of coverage on it, or the B&B is gonna give you a suspension.
I can prove that.
okay.
So you want more time? I mean, you could, here's my advice to you, and I've known you for a long time.
Yes, yes, very
We
long.
probably should continue this, because if I go ahead and process it, and it goes to the B&B,
Right.
it's a nightmare trying to deal with them. You'll be a lot easier dealing with us and bringing the proof here than try to get with them and get it worked out, because it's hard to get anything
Yes,
through
let's do that.
Okay.
Thank you.
How much time do you think you need to?
A week.
Maybe a month? Because it might be harder than you think, since it's out of state.
Okay, well then we'll say a month. I said a week, but a month would be good.
Yeah, I think we ought to build in some time to
Yeah.
make sure this happens.
Yeah,
And you're gonna be here on the 1st anyway, right?
Yeah, that's fine with me, Judge.
Let's try that.
April 1st.
Okay, April the 1st. If you get it and want to get it done before then, if you get your proof and want to come back earlier, Mr. Gallardo is here, we could put it on the docket sooner, but I think building in some time is a smart thing to do. Okay, so it'll be a sentencing hearing on April 1st.
Don't leave that. Let me talk to you out there. I'll try to get this done. I'll try to figure out what you need to do.
Okay. I might even have it in the car.
Okay, you check. If you do, we can have it maybe done today.
Thank you. Something from your insurance company saying they had coverage on you the day you got this ticket.
Right.
That's what we gotta have.
Thank you, Judge.
You're right. Or if the previous owners cover, I don't know if they would cover you. That's the problem. Once it's sold, they probably aren't gonna give you.
Well, that was under our agreement because I'd given it a little extra to keep it on there so I could get the car from point A to B to get worked on.
The problem is, it's not up to him, it's up to his insurance company, and I know insurance companies.
Yeah.
They'll fly out from any coverage as soon as they can. So that's gonna be the problem.
All right.
Okay, let's see if you have that card. Okay. Thanks,
State of
Judge.
Ohio versus Jet Porter, case number CRC 231142, A and B.
This is Mr. Dwyer's case at pretrial.
Judge, we're going to wind up having to have the suppression hearing in this. Today was supposed to be sort of a pretrial on the suppression.
Okay.
I've met with Mr. Heald and others in his office repeatedly over this case, and we're trying to get it resolved, but at this point, we do not have it resolved. So if we could go ahead and get a date for the suppression hearing, that'd probably be the best thing to do.
Well, I know you're here on the 1st, but we've already got a trial set that day. I don't know if
That's
they'll
fine.
go or not. A lot of times they don't.
It's mine. I think that one actually will.
Okay, so we probably need another date then.
Okay. The 22nd? How's the 22nd look? April 22nd.
April? Okay. So, it's fine.
Okay.
Set it at noon then.
Okay.
April 22nd, motion hearing for evidence at noon.
Thanks, Judge.
You're welcome.
State of Ohio versus Dylan T. White. Case number TRC 23-1818, A, B, and C.
This is Mr. Delar's case. I have it, is it a sentencing judge?
Did you take it this way?
Yes, Your Honor. Mr. White, this is a first offense OVI, and the score was on the aggravated side. And I believe that the intention here is if Mr. White started and completed some alcohol counseling, that the state may be agreeable to treat this as a unaggravated for sentencing purposes. He's in the middle of that right now, so he is enrolled in treatment.
Where's he going?
With, is it Lawrence County Recovery?
Yeah, the Marion Roberts.
Lawrence County Recovery with a lady named Marianne Rogers. I have an update from her. You had it in your file there. I'm sorry, it's with the Family Medical Centers.
Okay.
No, sir.
Yeah, is this our copy or?
Yeah, you can.
Okay, it looks like he's making steps toward making sure this doesn't happen anymore. That's what I want to ensure, that
Right.
we get this squared away and we don't have these kind of issues coming up again. So,
And so I think Mr. Heald would prefer to see a little more progress before resolving the case, which is fine with us.
want to do that April 22nd date?
That'd be fine, Judge.
Just did. Okay, April 22nd will be the next hearing for sentencing.
Thank you, Your Honor.
You're welcome.
State of Ohio versus Yuan Song Chen. Case number TRC 24-331, A, B, and C.
All right, Mr. Chin is represented by Mr. DeLauder, and I understand he's got a friend that's going to translate for him.
Yes, Your Honor. There's a little bit of a language barrier, so I thought it would be appropriate to bring somebody that was a little more fluent in English. I have talked to the defendant about what we're about to propose as a resolution in this case. I believe he understands.
Yes, he understands.
Everything. We can go over it again as much as you'd like on the record, but here's the suggestion in this case. There are 3 charges, I believe. One is a, I'm not sure if the insurance thing just appears to be a no insurance indication on the ticket. The other charge is a driving under a suspended driver's license. And then, of course, there's the OVI charge. Mr. Chin has fixed his driver's license through the state of New York. It is valid at this point. It never should have been suspended. It was also an insurance issue there.
I'm showing on the ticket, it says he did have insurance, is it?
Okay, good.
Okay.
I've got proof of his insurance then.
Okay, yeah,
Okay.
the officers checked the box saying there was proof of insurance at the time of his citation.
Okay, good. And his license is now reinstated. So I think in return for a plea of guilty to the OVI offense, Mr. Heald is willing to dismiss the other charge.
Is that correct, Mr. Hewitt?
It is, Your Honor. There's also Mark Lang's violation. We would nolly it as well upon the plea to the OVI.
Okay, and sir, that's the friend that's going to translate for us. Could you identify yourself, sir? What's your name?
My name is Ming Yao Zhen. I'm his boss and his cousin.
Okay. And are you from New York, and you come in just for this, or are you local here?
No, I live in Ohio, Wheelersburg.
Wheelersburg? Okay.
Yes.
All right. So, if you would, can you confirm or discuss with Mr. Chin that he is changing his plea to driving under the influence to guilty in exchange for the state dismissing no operator's license charge and a lane violation charge? Those are going to be dismissed, but he's going to plead guilty to the operating a vehicle while being intoxicated. Would you confirm that with him? Did he understand that?
No, it's not. 酒驾，但是你那个驾照，你不知道什么原因是被那个纽约上面交通局是 suspended， 就是你当时就知道。Okay, so he said yes for the guilty for the DUI.
Right, he understands that.
He understands, but he has no clue of why the driver license was suspended.
That's okay.
Yeah.
They're dismissing the
Okay.
charge.
Okay. And would you also convey to him, he would have the right to have an official translator that is approved by the Ohio Supreme Court if he wanted one, but he's agreeable with you serving as translator. Could you confirm that with him?
就是你同意让我做你的翻译。
And the language, his native language is Japanese, if I understand. Is that right?
It's not.
It's not, okay.
It's Chinese Mandarin.
Mandarin, okay. All right. So,
That's my fault.
I'm sorry.
Oh, well, that's what I told you. I'm sorry, that's my fault.
Okay. So, does he feel comfortable proceeding the way we are today with understanding the proceedings? All right. Please ask him if he has anything he wishes to say to the court before I sentence him.
你想要说一些什么东西吗？比如说你想对，就是说想说一些什么东西对那个法官。我知道错。这就是 okay. He said it. That's his fault. Just to like after drink to drive.
I'm sorry, I didn't understand what you said.
He drive with after the drink some wine and beers and.
That's the charge that he's
yes,
facing.
yeah. He said, "I'm so sorry about that." But by the way, as the owner of the restaurant, I want to say that if he still can give his driver license and then he can go to work because
We'll address that after
Yes.
the sentencing. I think the judge will give him driving privileges for work purposes.
we have a trouble to like a staff shortage. So,
Okay.
He works for you at your restaurant?
Yes.
He can have, and I plan on giving him some driving privileges for work. He can drive for work and maybe a few other limited things, but he can't just drive for any purpose. For a period of time, he'll have some suspension of his driver's license. So, all right, anything else before we proceed?
Ask him if there's anything else before we proceed.
No.
No, Your Honor.
Okay. All right, so I'm going to go ahead and sentence him, and feel free to relay this to him as I'm talking about it, or you can go over it with him after court if you wish. He's going to have to meet with a probation officer too, and if you could stick around and translate for that meeting also, because I'm sure that Mr. Majors does not speak Mandarin, so you'll need some help there. Based on his alcohol score, I'm going to impose a $500 fine, order him to pay court costs. It's $125 court costs. He gets a 6-month license suspension that started the day of the incident, which was February 18th. So that'll run through August 16th. I'm giving him 20 days in jail, but I'm suspending all of it on the condition that he does 5 days on our community service program. He can do that on his days off from you. We have community service basically every day now, because we have it on Sundays at the dog pound, but he can talk to Mr. Major about that. Every other day he can come here to do community service. I'll give him privileges to drive to and from work, to come back to court for any additional hearings, to come to community service, and he'll have to go to what's called a driver intervention program. So that's a 3-day school he has to go to. If he doesn't go to that, then I have to give him jail. So he has to go to that school to avoid going to jail. And there's one in the county, in Wheelersburg. There's not one in Lawrence County any longer. There's one in Scioto County in Portsmouth. So you can go there. There's actually a cheaper one in Ross County if you want to go to that. You can go to any one that's approved by the state of Ohio. but the closest one is inside of town. He'll have a review hearing on September the 9th, so he's got all summer to get all this done. If he gets it done, he doesn't even have to come to the review hearing. It's just a hearing to make sure you do what you're ordered to do. If he finishes it, confirms it with his probation officer, he doesn't have to come to that hearing. His two other cases, he cleared up the driver's no operator's license. It sounds like it shouldn't have been suspended anyway. That's cleared up, so the state's dismissing it, and they're going to dismiss the lane violation too. So he only has the ODI. Mr. DeWater, if you could assist with him meeting with Mr. Major also, and sign up for probation, and that's it. Any questions?
Any questions? No?
So, even, we have a trouble too. I mean, we have a staff shortage on the weekend. I mean, if we can just, he doesn't need to go to any school, like a private school to.
I'll talk to you about that. Thank you, Your Honor. Thank you.
You're welcome.
All right, so you can't leave yet. We have to talk to the probation officer. I'll meet you in the lobby here in just a second. Okay.
Gotcha.
Got some more rain.
I told him he's gonna show it to Chris.
He told me to come. What was the date of the ticket? This may be the old one. Because I know I've got another one too.
Why don't you go talk about it?
Yeah, okay.
We've got some arrangements we can do, then we'll call you back.
Thank you.
Thank you.
State of Ohio versus Mandy Joe Hall, case number CRB 24116.
Ma'am, are you Mandy Jo Hall?
Yes, sir.
Ms. Hall has alleged that March the 8th of this year in Fayette Township, you tried to deprive Walmart of property without their consent. That is a first-degree misdemeanor. Maximum penalty is 6 months in jail, $1,000 fine. Do you understand the charge? Yes? Do you understand your rights?
Yes.
How do you wish to plead to these charges?
Guilty.
Guilty means you're admitting it's true, you waive your rights to have a trial and have a lawyer when you enter a guilty plea. Do you understand that?
Yep.
Okay. What I'm going to do is what I always do on these cases is I'm going to order you to go take a urine screen because I get a lot of people that test dirty who are shoplifting at Walmart. So,
I'm in outpatient treatment.
okay. Well, I still want to have you do a screen so I can see it. So go do that. Then you'll come back and I'll decide what your sentence should be after you get the results.
Okay. Where do I do that?
Just go out in the lobby and I'll direct you where to go to.
State of Ohio versus Brittany N. Vaughn, case number CRB 24117.
Ma'am, are you Brittany Vaughn?
Yes, sir.
This is also theft from Walmart. Bailiff's about to hand you a copy of the charge. It alleges that Fayette Township, March 9th, you tried to rob Walmart of property without their consent. That's a first-degree misdemeanor. Maximum penalty is 6 months in jail, $1,000 fine. Do you understand the charge?
Yes, sir.
Do you understand your rights?
Yes, sir.
How do you plead to this charge?
Guilty.
Guilty means you're admitting it's true and you waive your rights to have a trial and have a lawyer.
Yeah, it's hard for me to get down here. I have a disabled daughter, so I'm just completely guilty to it.
Okay. Well, I can give you a court-appointed lawyer if you feel like you're not guilty.
I'll plead guilty.
Okay, that, you understand, if you enter a guilty plea, that's an admission that the charge is true. Do you
Yes.
understand that?
Yes, sir.
Okay, I'm going to accept your guilty plea, and I'll ask you to go do a urine screen also and come back, and I'll send you after I get the results.
Okay, sir. Thank you.
You're welcome.
State of Ohio versus Kelly R. Mintz, case number CRB 2366 A, B, and C, CRB 18326.
All right, Kelly Benz, that's you, ma'am.
Yes, sir.
And let's see, you had a hearing, looks like the hearing that you missed was January 22nd. And that was for review on a theft offense and two theft offenses. One in 2018, one in 2020. Do you admit that you missed those hearings?
Yes, sir.
Do you have an explanation for that?
I was in Georgia and I was supposed to do it on video court, but I couldn't get the video to work. I had it on Blue Jeans, but I couldn't get the new one to work.
Zoom? So
Yeah.
Zoom now. So did you come back here just for this, or are you living here now?
I moved back here. I was in Georgia helping my sister because she just had a baby, but I've moved back to West Virginia now.
Okay, where you were living in Chesapeake at one time last summer, right?
Yeah,
Are you still in treatment?
yeah.
Where do you go to treatment?
Over in Huntington, HHG. I don't do weekly treatment anymore. I just go monthly and just get an injection, that's all.
Okay, because I hadn't screened you before, so I want to go ahead and screen you today. Go do a screen, come back, and then we'll decide how we're going to get forward. So go do a urine screen. Okay, we're going to go back to some pre-trials.
State of Ohio versus David Lee Labor II, case number CRB 23757.
Mr. Smith's case set for pre-trial.
Judge, there'll be a change of plea.
I can change the paper.
That's okay.
I give it to him.
Give it to me and we'll...
I gave him a place. I was remember I was that one guy that came here with me? That was at Cardinal, for Cardinal, and Miss Lurie told me to give this to you.
And Judge, what the proposal is would be 30 days all suspended, and a condition of probation is that he completes treatment either at Mahajan or Cardinal or wherever.
Mahajan's where I was.
Mahajan now.
Cardinal is where I was going through outpatient. Well, I was inpatient. And that's they messed the dates up though. They're 24. They ain't 24 yet. But they told Miss Lurie told me to give that to you. She said, make sure you give that to that to your judge. Make sure. So I gave her my word. I had to. I give you my word. I got some word. Man ain't worth a darn if I ain't got the word. It ain't worth a darn. I mean, it's not at all.
So he's at Mahajan now?
That's what I understand, Judge. He was at Cardinal outpatient, he's out in Mahajan, and the agreement was he would have to, as part of his probation, successfully complete his current treatment at Mahajan, or wherever else he might wind up. But
Okay. So, Mr. Labor, do you agree with your lawyer? You want to change your plea at this time?
It's fine.
He said that's fine, just speak up.
I go home.
Yeah.
Okay. Is there anything you want to tell me?
I got probation or anything?
Not, well, probably you will, but you haven't yet. I haven't sentenced you yet.
Well, if I do, can I get as much community services as possible to get my fine and stuff worked off?
You can work off your fine by community service.
All right.
And we just leave the fine up to you, Your Honor. But
Okay. Anything else you want to tell me? Okay.
Thank you.
You're welcome. I'll accept your plea. I'll impose a $50 fine and court costs, 30 days in jail, all suspended on the condition that there's no further problems and that you finish your treatment with Mahajan.
Can I get a copy of all of it?
Yeah, you're going to get a copy of your judgment.
We're also requesting a no contact order, Your Honor.
Okay. Or stay away from,
Sam Conley. Hello. I told my dad, I said, when I go home, he says, how do you do it? And everything be right next door. I said, Dad, I said, I go home. I like I'm in the middle of the woods, I'm the only house there.
so you got to stay away from Sam Conley.
Yes, sir.
Okay. And I'll set his review hearing for September the 9th. We'll need to meet with Mr. Major. I'll make it level 5 probation.
My dad will probably be in here later to pay on my fine. Because I went out of town, I make a little bit of side money here and there every now and again. I never know when I get to go out or not. But I've been saving $200 to pay on my fine court costs with this place, with you.
Okay, that'll pretty much take care of it.
Yep, that will?
Yes, sir.
Oh, heck yeah, thank goodness. See.
Okay, he'll need to meet with Mr. Major. You'll assist to make sure that happens.
I will make sure that happens, Judge. Just wait up, I'll be out in a few minutes and talk to you, okay? You'll just wait there in the lobby, I'll be right there. So, there's your, yes, yeah, just in the lobby.
State of Ohio versus Kathleen Leftwich, case number CRB 2456.
There are two co-defendants. Mr. Morford has one, and Mr. Steyer, if we can maybe call those all three.
What are their,
Oh, it's Alpha Donnelly and Rachel Harvey.
And Your Honor, I'm making my first appearance with Ms. Harvey.
State of Ohio versus Alpha Donnelly, case number CRB 2457.
that's Mr. Morford's case?
Yes.
And State of Ohio versus Rachel Harvey, case number CRB 2458.
That's Mr. Starr.
This one.
Yes, sir.
Phil?
Yes. Do they all want to do that?
My client does. In which case it's submitted, right? Either one, charge.
Yeah.
No, he didn't dismiss, was he good with that? He dismissed it. Okay, dismissed. Be dismissed. Sounds like we're all in agreement, Judge, as the state's recommended. Yeah, 90-day dismissal, I guess, there's one court cost, or we can discuss that.
So, my main concern is that this, whatever was the root of this is not going to happen again. What's the relationship between the three of you? I assume there's some kind of relationship.
At one time, one of the ladies was dating him, and things went kind of south. Is that a fair assessment? They had a little confrontation, but
Okay.
my client says that's not going to be a problem.
So, yeah, we got to the root of that, that's not going to happen. I don't want to just gloss it over and then somebody gets hurt down the road.
We've not had a problem, you know, this has been going on case-wise about a month at this point, I think, and there haven't been any further problems. I think whatever issue arose that day has passed.
Okay. So, and is this with or without cost?
We'd ask for one cost.
And how are we going to do that?
Who wants to volunteer?
The court cost would be about, what is 120 now?
125 plus 150 total.
Well, I'm not more than her case, so.
Okay, 125.
So it'd be $125. Okay, she'll pay the cost.
What was her name?
I'm sorry, Harvey.
Rachel Harvey.
Thank you.
Okay, so we're gonna go 3 months out. If there's no further problems, then the cases will be dismissed upon Ms. Harvey paying 1 court cost. And none of you would have to appear at that next hearing on those conditions. That's agreeable with everyone?
Yes.
Yes.
Okay, so let's look, so that's June. June 10th, just right at 90 days.
That'd be fine, Your Honor.
Let me big set on my calendar, I've got. Yep, that works.
June the 10th, but you don't have to appear as long as you don't have any further problems and the cost get paid. Any questions?
Yes, Judge, she has a protection order against Mr. Donnelly. She's wanting to drop that. They have a child in common, and she doesn't believe it's necessary to have that in place any longer.
Are there any other protection orders in place? Do you care to drop it? Do you have any
I think everybody got one that first appearance.
Does anyone want a protection
That's
order?
better.
Maybe that's the easier way.
You don't want protection. My client does not, Judge.
Okay, so any protection orders are dropped at this point.
All three.
Any questions? Everybody knows what they need to do.
Not on behalf of Ms. Lefferts, Judge.
We're nothing further from Ms. Harvey.
Any paperwork that you get a copy of saying that stuff will be dismissed and this there? Okay, then I'll get.
Thank you, Your Honor.
Thank you,
Anything
Judge.
else, Mr. Morgan, Mr. Donovan?
No, sir. We're good.
All right. Free to go.
Thank you.
You're welcome.
State of Ohio versus Matthew Smith. Case number CRB 21692, CRB 15457, CRB 14563, CRB 14665, CRC 12627, and Z.
What's his name? That's fine.
Judge, we believe there's going to be a resolution. The state's going to recommend they suspend the jail sentence. Can we discuss how much time? 30 days?
Yes.
30 days suspended, and the fine up to the court, the condition of, a specific condition of probation is he pay restitution. I believe it's $230. He brought $220, which he will pay today. Of course, he'll still have fine and cost to pay, but he'd like the initial payment to go towards that restitution, and that was my understanding. The prosecutor wanted that as well.
So there's a change in plea. This is case number 21692, correct? Involving Sherman Collins as the complaining party. Is that correct, Mr. Smith?
It is correct.
Yes, sir.
And Mr. You're both Mr.
Yes, that's why I answered yes.
And either Mr. Smith, do you have anything you wish to say before I conclude?
No, sir.
Okay. All right, I'll accept the plea. I'll impose a $200 fine, order the cost be paid. Did you say 30 days is what was recommended?
That's correct, Your Honor.
30 days, all suspended on the condition that restitution be paid in in the amount, was it 230?
That's correct, Your Honor. 230, he's got 220s, correct.
Now, our condition was that he has 220 to pay today. He
Right.
still owes 10.
It was $10. He
Yeah.
assures me he will get that.
Restitution is $230 to Sherman Collins. 220 of it's going to be paid today. When you see the clerk, make sure, and they need to know, because you've got some other cases, and typically they'll try to apply it to the oldest case first, but this money today needs to go toward the restitution on the case that we're handling, 21,692. And you still have some other costs and fines, and you got some old fines and costs that have to be paid too. So 2 years of level 4 probation on this. And I'm going to set a review hearing because he's got other cases. April 22nd. April 22nd will be his review hearing. On all his cases.
That's case
It's got a CRV number.
He'll need to meet with Mr. Major and then go to the clerk. He can bring up with Mr. Major about the restitution, but then if that restitution, either Mr. Major will help him with that or he'll go to the clerk with that.
Thank you, Judge.
Thank you.
Go to the office on the left.
State of Ohio versus Matthew White, case number CRD 23576, A and B.
White's at Bethesda. Okay, it's a good report.
I'm almost done.
Good.
You might come back one more time. Get you over the
Do
finish
you have
line.
a projected date for
So the 28th, it looks like? March, okay, approximately, yes.
I'm here the 5th, Judge, the 5th or 8th of April.
Yeah, the 8th's better, if that's okay. April 8th.
Now, do I have to, I'm going to sober living after this. Do I have to wait until the 8th before I can proceed with that, or do I?
No, this won't stop.
He's going to a different facility for sober living.
Where are you going to go?
Southern Hope?
Okay. No, that'll be fine.
Okay, thank you,
But I'll
sir.
just want an updated report then.
Yes, sir.
Thank you, Your Honor.
You're welcome.
Thank you, Judge.
State of Ohio versus Amanda Hicks, case number TRD 1804, CRB 12456, CRB 08162.
All right, Mr. Morford's her attorney. It's my understanding she is at OED now.
Yes, Your Honor. The plan right now is for her to complete detox. She shouldn't have returned to the methadone clinic. We're working on getting her transitioned to another NAT, and then over to Bethesda.
Okay,
And we have a warrant resolved in Portsmouth, so the only thing that's holding her is here.
okay. All right, she has an ankle monitor now. so she
Yes.
has it. How's she doing?
She's doing good.
Good. So will she do the whole 30 days, or will she be released before then?
Right now, it should just be detox only because we weren't going to allow her to return back to the methadone clinic because she hadn't dosed in so long.
Okay. So she kind of detoxed while she was, or detoxed from methadone anyway while she was in jail.
Yeah, so as soon as medical deems her fit to continue to Bethesda, we'll send her over.
Why don't we come back in a couple of weeks and to see, keep track of it. That's the 25th, Mr. Worker, you here then?
I am, Judge.
Okay, I'll reschedule her next hearing for March 25th. We'll call a pretrial on review. Okay.
Thank you, Your Honor.
Good result. Glad she's doing well.
Yes, thank you, Your Honor.
Thank you, Judge.
State of Ohio recalls Mandy Jo Hall, case number CRB 24116.
Okay, and tell me again, where did you say you were getting your treatment?
At Mahajan.
Okay,
Yeah.
how long have you been there?
Just a couple weeks.
So that's outpatient, right?
Yes. I just started a job at the Frieza in Colgrove, and I have a 10-year-old little boy.
Okay.
I was reading the back of this, and most of it is about my husband, and it says that I did not willingly know that he was changing UPC tags.
Well, do you want to change your plea to not guilty? And here's the standard. The state has to prove that you intentionally took something that belonged to Walmart. And just being with someone else that was stealing is not enough to get a conviction. So if you didn't have knowledge or weren't involved in assisting him, then you're not guilty. So I can appoint a lawyer for you to represent you.
I'll just take the guilty. Because when I watched the camera, and on camera it looks like I know what he's doing, but I really didn't.
Okay. Well, then I'm going to enter a not guilty plea because that's important. If you're telling me you're not guilty, but you want to enter a guilty plea, so I don't have to accept your guilty plea, and I won't. Since you're telling me you're not guilty, I'm going to enter a not guilty plea. And you have a child?
Yes.
One or more?
One. He's 10.
And did you say you're working in care?
I work at the Frieza in Colgrove.
Frieza, you did go. How much are you paid by the hour there?
Yeah.
How much per hour?
$10.50.
Okay, you're also before appointed counsel. So, Mr. Smith, I'll appoint you.
Yes, sir.
And you heard her.
I did,
statement.
Judge.
So, I'll let her, well, she's got a bond up, so the bond's going to be continued. And we'll come back for a pretrial. Was he here for arraignment also, or?
He's in jail.
Okay, well, I haven't done him yet.
No.
Well, we probably should, because I may have to have his hearing pretty quick. How about the 22nd? Are you available?
I'm here the 18th or 29th, Judge. I have a trial that Friday, one-day jury trial.
I'll set it for the 29th.
I can do that.
Next hearing is March 29th for pretrial at 10 a.m.
State of Ohio recalls Kelly R. Mintz, case number CRB 2366, A, B, and C, CRB 18326, CRB 24. That's all.
Okay, and I'm assuming you're getting prescription for buprenorphine?
No, I don't get a prescription, I just get an injection once a month.
Okay. Okay, you had an appropriate screen, so I'll just reinstate you to...
Okay, and I paid on my fine last week online, and I want to pay some more on it today. but she told me to wait till after I came in here.
Okay. I'm showing you community service and fines.
Yes, Your Honor.
Okay, so
Did you say, I heard you earlier say something about doing community service on Sunday at the animal shelter?
you can.
Okay.
Talk to Mr. Major about, here's the only thing about it. Community service here at the port, you can show up any day at 7:30. To do it at the dog pound in Ironton on Sundays, you have to, they can only take so many people. So 10 people show up, they can't use them. They only have so many slots, so you have to pre-arrange. You have to call, kind of make an appointment that you're going to work with them on a Sunday. He can tell you how to do that if that's what you want to do.
And do you think it would be okay to show up, like during the week? I drop my son off around 7:30, between 7:30 and 8. Would it be okay to come for community service after?
Mr. Cooper says that's fine.
Around 8, okay.
He's in charge of community service. Okay, so, I'll go out for your next review hearing to April the 11th, so exactly 1 month. 9 o'clock.
Thank you.
You're welcome.
State of Ohio recalls Brittany and Vaughn, case number CRB 24117.
Okay, you had a good screening.
I have 5 kids, so I've got to take care of them.
Well, believe it or not, I get a lot of people that have got kids and they test dirty. So it seems like I've had a rash of younger women with kids recently with substance use issues. So I'm glad you don't have that.
My kids come first.
Okay, anything else you want to tell me before I send you on this?
No, I do have to say community service would be hard for me.
And you live in Ashland?
Yes, sir.
Well, it's supposed to be hard. I mean,
Okay.
it's supposed to be a penalty, so that's part of it.
It's the babysitting thing. I don't have a babysitter.
Well, here's the thing. I usually give you a jail sentence. I'll suspend it on the condition that you do community service. I would assume you'd rather do community service than going to jail, right?
Yes.
Okay. So you gotta look at it that way. This is a lot better than going to jail. So, on anything else you want to tell me before I sentence you? Okay, there'll be a $100 fine, court costs, 10 days in jail, suspended to 5 days community service. That's a good deal.
Okay.
5 days community service versus going to jail for 10 days?
Okay, I drop my kids off at school because I got 2 middle schoolers and an elementary schooler, so I wouldn't be able to get here until about 8:30. Is that okay?
They'll work out something with you.
We'll work out something.
Okay.
Of course, they could always ride, I know this is a really strange thought. People don't think of it these days. You know what I'm going to say. School bus. I rode a school bus every day to school until I was old enough to drive to school.
Well, I live in Ashland and they go to Bowie County, so I have to take them. They're out of school.
They don't have a school bus?
They're out of district.
Oh, okay.
Because we moved, and then they stayed in the same school district they was in.
Okay, well, it's something, I mean, you can work on Saturdays too,
Okay,
or Sundays at the dog pound.
okay.
Just
You guys are open Saturday?
The community
Oh, okay.
service is here on
Okay.
Saturdays. Okay, so, her review, was that what you're, September 9th? So you got all summer to get this done.
Oh, okay.
You're also, this is the worst part of your sentence. You gotta stay out of Walmarts.
Okay.
Where you stay out of Walmarts.
Another guy told me to call up there after my sentence and stuff to Walmart, and they might be able to revoke that.
Well,
So
not that I know of, I don't think, I know Walmart's very powerful, but I don't think they can change court orders, so.
Yeah. No, the guy at Walmart was telling me that.
I don't doubt.
After a year or something like that.
All right, September the 9th is your review hearing hearing, check in with Mr. Major, probation, and you're free to go after that.
Okay.
State of Ohio versus Charles Alhart Jr. at the Lawrence County Jail, case number CRB 24118.
All right, sir, are you Charles Hall?
Yes, sir.
Mr. Hall, I'm Judge Capper at the Lawrence
Yes.
County Municipal Court in Chesapeake.
How you doing?
I'm good. Can you hear me okay?
Yes, I can. You hear me?
Yes, I can. You have a right to remain silent. You don't have to make any statements. If you choose to make statements, what you're saying is all being recorded and is on the record. It can be used against you.
Yes, I know, Judge Captain. I know this is my second offense. I'm supposed to have court with you, I believe, next month, and I'm supposed to have community service. And I'm in rehab through my husband, and I relapsed, and I got my father, went back to Walmart with my wife. She was just there, Randy Hall. She was just there, I believe. Checked with you this morning also, and I had to relapse because I felt some violence and I took it, and she was paying for stuff, but I thought she was paying for it, and I was putting it in the bag and dumping, you know what I mean? So I'm guilty right there, but very much different, like no sense around it, you know what I mean? I'm just want to ask for like a leniency so I can continue my outpatient rehab or inpatient.
Okay. The charge against you alleges March the 8th of this year, you tried to deprive Walmart of property without their consent. So first degree misdemeanor, maximum penalty, 6 months in jail, $1,000 fine. Now, in addition to having the right to remain silent, you have a right to have a lawyer, to have one appointed if you can't afford one, to have bail, and to make the state prove this charge beyond a reasonable doubt. Do you understand those rights?
Yes, I understand those rights. Your Honor, there is done all of that because, I mean, I am guilty, you know what I mean?
Okay, so you want to enter a guilty plea?
Yes, I do want to enter a guilty plea and lenient in rehab and patient OVP.
Okay. Do you have a medical card?
Yes, I do.
Ohio?
I'm Medicaid. Yes, I do.
Have you been to inpatient treatment before?
Yes, I have.
Where?
OVP. I'm very well acquainted there. I like it, and I graduated once already.
When was that?
That was just a couple months back. Just a couple months back I did.
I don't know if they can take, can you check to see if,
Yeah, I'll check to see if we have a bed. He did complete our program not long ago though, so I'm sure they wouldn't mind to take him back if we have a bed.
okay, well this time when you finish it, you're probably going to need to go for some additional aftercare when you finish OVP.
I will go to transitional living.
Okay, well you don't get to decide that, I'm going to decide.
Okay,
I'll decide where you're going to go.
okay. I appreciate it.
All right, so I'll have you back. The representative from OVP is here in the courtroom. She heard what you had to say, so she's going to check to see if they're willing to take you, and then I'll deal with you once I get that information back. We'll decide how we're going to do this.
I appreciate it, Captain.
You're welcome.
State of Ohio versus Armando Barrazo Jr., case number CRB 24119, A and B.
Answer, are you Armando Barrazo Jr.?
Yes, sir.
I think the bailiffs just handed you a copy of the charges. There's two. Domestic violence is the 119A case. It alleges March the 9th, you knowingly caused or tried to cause physical harm to Lisa Barrazo, she's either a member of your family or a member of your household. It's a first-degree misdemeanor, maximum penalty 6 months in jail, $1,000 fine. The B case, 119B, alleges that at the same time and place, you knowingly caused Elizabeth Bianco to believe you would cause physical harm to her person or property. That's a menacing charge. It's a 4th-degree misdemeanor. Maximum penalty for that is 30 days in jail, $250 fine. Do you understand these 2 charges?
Yes, sir.
Do you understand the rights you have?
Yes, sir.
How do you plead to these charges?
Not guilty.
You want to be considered for a court-appointed lawyer?
No.
You got to hire your own lawyer?
I don't need a lawyer. I have my side of what happened. I have my wife had to dispute everything that happened there, so that's her right there.
Okay, well, let's see what the prosecutor says. He's talking to her now.
Okay. I do have a question, though, if anybody has one. This female, Elizabeth, whatever her last name is.
Bianca.
Yeah, I didn't press charges on her because she damaged our vehicle in the process of all this, which I never laid a finger on that girl. So how do I go about doing that?
Contact the sheriff, or where did this happen?
At this residency, 317 Keith Avenue, Keith Street? The place it happened, it was called to, that residence there. Because the officer, I think his name was Thompson.
Perry Township?
Yeah, the officer Thomas, or Thompson, whoever one that was there, he took pictures of the vehicle of the dents that she had kicked in there.
You should contact the sheriff's office.
Can I get that information from you guys before we leave? Yeah, okay, I'll leave.
Clark can give it to you.
Okay.
Mr. Hill?
I've spoken with Lisa, is it Barrazo, is that how you say it? And she does not want a protection order. And we are not prepared to dismiss the charges, even though she has indicated she doesn't want to proceed. What we'd like to do is set this for a pretrial. We haven't spoken with Ms. Bianco yet. Is she here, Elizabeth? So we would want to get her input on this as well. It sounds like Mr. Barrazo has some intention to try to file a charge against Ms. Bianco too, so.
Okay. And you're sure you don't want to be considered for court-appointed lawyer?
I mean, I guess if you guys give one out, then I would assume, yeah.
Are you working?
No, I'm retired now.
Do you have income though?
I have some income, yes.
Okay, because I'm not just being nosy.
Oh, no.
There's a standard I have to go by for a court-appointed lawyer. If you have a certain level of income, then you're
me and a friend of mine, we pick up vehicles, fix them, and sell them on the side. I mean, that's what you call it. You know, it's a hobby pretty much. You know what I mean?
Do you file an income tax return every year?
We do a joint filing, but I mean, it's not a job. We just do it on, you know, I don't pay taxes on a vehicle like that. I pick them up, fix them, and someone wants to, you know, resell it, you know.
Well, what I'm trying to find out, our Supreme Court, Ohio Supreme Court tells me I have to determine your gross annual income.
Oh, I mean, for myself, I don't know, maybe $20,000 a year. I don't know.
Okay. Do you have dependents?
Yeah, my wife and my 10-year-old son that we have together.
Okay, you're eligible for a court-appointed lawyer then. Mr. Morford still here?
The clerk said that he said he'd see him next week.
Okay, anybody else here?
Steyer.
Mr. Steyer?
He said hand writing, he said.
Okay, well, Mr. Steyer's in the courtroom, so I'll just appoint him. Mr. Steyer will be appointed to represent Mr. Barrasso. Let's see.
That's yours. Okay.
So we probably need to come back fairly quickly because the one charge is a 4th degree misdemeanor. Do you want a protection order?
On the B case, yes, please.
Okay, so I'm going to order you to stay away from Miss Bianco, since you don't know who she is. I would assume that's pretty easy to do.
Oh, yeah, I don't know, no.
Okay. And then we need to come back for a pretrial. Is the 22nd, Mr. Sire, are you available then?
I am, Your Honor.
Okay, March 22nd is going to be the next hearing. It'll be a pretrial at 10 a.m. There is a order issued to stay away from Ms. Bianco. And any questions?
Nothing at this time.
All right, thank you.
Just wait for me to log over and talk to you a minute or two.
Okay, we're starting some preliminary hearings now.
State of Ohio versus Dean J. Fields, case number CRA 23715, CRB 23656.
This is Mr. DeWaters' case.
Your Honor, we are agreeing to amend the felony domestic violence to a misdemeanor upon his plea to that charge. And then we are going to ask to delay sentencing on both that and we will leave the theft charge open without a plea at this time until a later date. Parties are in the process of finalizing their divorce, and we feel like in order to allow them the space to do that, this is the best way forward.
Okay, and is there a projected date on when that's going to be?
Yes, Judge, we're set for, well, actually, we're set for a trial on March 22nd, but I believe we've got the divorce resolved. It's just a matter of putting it all on the record.
Okay, and then I'm assuming, ma'am, you're Sarah Fields, is that correct? You agree with what the lawyers are representing to me?
Yes.
And I'm assuming you're represented in the divorce proceeding?
Yes.
Who's your lawyer?
JT Holt.
Okay. And he's aware of what's going on here? And he's in agreement also with how this is being handled? Okay. So, on 23-7-15, we're going to amend that to a misdemeanor, be an M1 then? domestic violence?
Yes,
That's my understanding, Your Honor.
Leave it open without a plea at this point?
No, my understanding was Mr. Fields would enter a no contest plea to that charge with a stipulation to facts sufficient for a guilty finding.
All right, so that'll be amended to an M1. That's 23715, case number. And Mr. Fields, do you agree with what your attorney has represented to the court?
Yes.
Do you have a statement you want to make before I proceed?
Yes, sir.
But on sentencing, we're going to wait until things are concluded in the divorce.
If that's okay with the court.
Yes, so sometime after the 22nd of March.
Yes, so...
April 1st, you want to...
That'd be fine with me if that's okay with you.
I know you're here that day.
Yes, sir. And then...
Mrs. Fields, is that agreeable with you, April 1st?
Yeah, that's fine.
And then,
That's a
Judge,
Monday.
one other thing that's going on here, the anticipation is that, assuming there are no further problems and we get through the divorce case as intended, that the recommendation will wind up being a probated sentence on April 1st. If there are problems, then it won't be. Then we'll have to have a sentencing here.
Okay.
However, Mr. Fields is about to depart for Montana for a work assignment. Part of the divorce involves him paying a pretty good chunk in child support. And so I'd like for him, if there's not been any further problems, I wonder if he can appear remotely or if he can authorize me to appear on his behalf for the sentencing portion of the hearing. And then if we need him here, I can reschedule it and advise him he has to come back. Is that okay with everyone?
Mr. Hugh?
Yeah, if there's a problem, then we just have to reschedule it. That's fine.
Okay.
Okay, so he can hopefully appear by teleconference
Yes, sir.
on April 1st. And it'll be marked as a sentencing hearing. That's assuming there's not going to be any. And there'll be a pretrial on 23-656.
Correct.
So that's assuming there's not going to be evidence taken. If there's going to be evidence taken, then we'll have to reschedule.
All right.
So April 1st is the next hearing at 10 a.m.
Thank you, Your Honor.
Thank you, Your Honor.
Don't leave yet. Let me talk to you before you leave.
State of law, we call Timothy Atkins. Case number TRC 23-1834 A and B. Next step in this case, Your Honor, will go to the Lawrence County Jail.
This is Mr. DeWaters' case at the pretrial.
Judge, I was provided with some updated discovery today on this case. I'd like to have an opportunity to evaluate that and speak with Mr. Atkins about potential resolutions. We've said a lot for the first. I got a couple on the 22nd too, if that's a better day.
That's fine.
Okay.
April 22nd will be the next hearing on this for pretrial at 10 a.m.
All right. Thank you, Your Honor.
You're welcome.
State of Ohio versus Justin Bates at Lawrence County Jail. Case number CRV 24-120. Nicole Cosner is on deck.
Okay, here he is. All right, we need Justin Bates is at Lawrence County Jail appearing by teleconference. Is that you, sir? Are you Justin Bates?
Yes, sir.
And can you hear me okay, Mr. Bates?
Yes, sir.
I'm Judge Capper. I'm the judge at the Lawrence County Municipal Court, which is in Chesapeake, Ohio, which is where your case is actually filed. You're appearing on a television monitor in the courtroom today, and everything you say is being recorded. So if you make a statement, it could be used against you. You don't have to say anything. You can remain silent if you wish. You have a right to have an attorney, to have one appointed if you can't afford one, to have bail, and to make the state prove this charge beyond a reasonable doubt. Do you understand those things I just explained to you?
Yes, sir.
Okay, the charge filed against you is a theft offense. It alleges that on March the 9th in Fayette Township, you purposely deprived Walmart of property without their consent. That's a first-degree misdemeanor. Maximum penalty is 6 months in jail and a $1,000 fine. Do you understand the charge?
Yes, sir.
And you understand your rights I just explained to you?
Yes, sir.
How do you plead to this charge?
I plead guilty, sir.
That means you're admitting it's true and you're waiving your rights to have a trial and a lawyer when you enter a guilty plea. You understand that?
Yes, sir.
Okay. What I'm going to ask before I sentence you, I'm going to ask the jailer to give you a drug screen, because I find a lot of people that are shoplifting have drug issues.
I'm going to test positive, Your Honor.
Methamphetamine?
No, sir.
What is it?
Suboxone and crack cocaine.
Okay. Well, just to make sure, I want to still do a urine screen, then I'll have you back, and I'll decide what your sentence is after I get the results. So they can give you a screen there at the jail.
Yes, sir.
State of Ohio versus Nicole Cosner, case number CRB 2450 A and B. Michael Davis is on deck.
Nicole Cosner.
How are you?
Good. How are you?
Get better.
Okay. This was bond revocation happened due to leaving treatment in February. And she got arrested and now is before the court, and she was at Bethesda.
She was.
I wasn't trying to leave. I found out that my house had been broken into and my dog was gone, so I was trying to figure that out. And I planned on going back and I was kind of stuck down the house. That's why it's cool as well.
Okay. After you got that figured out with your dog, did you go back to counseling?
No, I didn't have a way, actually. I had planned on it, but like I said, I was just stuck down in the holler where I live.
Is that County Road 128?
Yes.
What's the common name of that?
Rock Holler.
I'm going to go out on a limb and say Bethesda would have come and picked you up if you would have called.
Absolutely.
Yeah, that's another thing. I don't have a phone, period. I don't have a house phone. I don't have a cell phone.
She also has a common police case too.
Oh, okay, so you've got something in common pleas also, right?
Yes, sir, I do.
Okay.
I would like to go back, honestly.
Well, we're gonna have, that's probably the best result you could get. Who's your lawyer? You got a lawyer in common pleas yet?
Davenport?
You start taking appointments to get judge, Mike
Okay.
Davenport.
Yeah.
Okay. Well, you're gonna have to run it by common police court. And did Mr. Sowards come and get you? How'd you wind up being in jail?
No, I was someplace where the probation showed up and they ran my name.
Okay.
She may be on the docket this Wednesday. Either way, somebody will be in court, so we'll see what we can do.
That's what I was hoping for. I was hoping that I would be able to go Wednesday and maybe go back to y'all.
Okay, which judge do you have?
Ballard.
Okay.
She is Ballard, yeah.
Well, I'll lift my warrant on you so he can decide what should happen with you. I saw him this morning at breakfast. I did not know you were in jail, or I would have mentioned it to him then.
Oh, shoot, that sucks. That's just my luck, though. That's how it goes.
Sucks that I would mention it to him, or that I didn't mention it to him. I don't know which. Well, I didn't know you were in jail.
Maybe I could have got out and lived today and had been taken to court on Wednesday. That would have been nice. I've been a lot better to leave, that's for sure.
Okay, so what I'm going to do, I'll just put you back on our docket for this Friday, and so that way I can find out where you are. If he releases you to treatment, if you haven't seen him yet, then I'll just talk to you like this. So I'll release the warrant, set it for a pretrial. I'm going to text him and tell him what's going on and suggest that you go to treatment with an ankle monitor, but that's going to be his call.
Okay, so I'll be here until Wednesday?
At least.
Okay,
Okay.
all right, thank you.
So if you go into treatment, if you go back to Bethesda, then they'll make sure you're here Friday, or they'll communicate with me about your case. But I need to know what's going on by Friday.
Okay,
Thank you, Your Honor.
yeah, thank you.
You're welcome.
State of Ohio versus Michael Davis, case number CRB 24-114, TRD 06-2574, CRB 07-652, and Samantha Gonzalez is on deck.
That's fine, you don't mind that. Sorry. Text Judge Ballard about it. Okay, Michael Davis is in custody at the jail, and it looks like there's some new charges.
Yes, sir.
Sir, you're Michael Davis?
Yes, sir.
I'm Judge Capper. This is your arraignment hearing. You have a right to remain silent. You don't have to say anything. You make statements. It's all on the record and can be used against you. You have a right to bail and to make the state prove any charge beyond a reasonable doubt. The new charge is a domestic violence charge. It alleges that on March the 10th of 2024 in Union Township, you knowingly caused or tried to cause physical harm to Brandy Trailer, and that she's either a member of your family or household. That's a first-degree misdemeanor. Maximum penalty is 6 months in jail, $1,000 fine. Do you understand this charge?
Yes, sir.
And you understand the rights you have as a defendant?
Yes, sir.
Have you been representing Mr.
Your Honor, I have him on cases that are currently pending, also involving Ms. Trailer. We were here last Monday.
I was going to say, we were here recently.
Yes. And we're not scheduled back on those until April 4th or 5th, I can't remember. I just looked at it, around my head. On April 5th.
Okay, I'll point you were appointed on this for our cases. I'll point you on this, enter a not guilty plea.
Yeah, we'll enter not guilty plea. We'll waive any further reading, I don't think there's anything further to be read.
What's the state's position on bond?
Was there a bond that was posted previously?
I don't believe, I think he may have been on an OR bond.
Looks like he was. They're old cases. The previous ones were old.
Well, so
we
we got one from January 29th. Is that this one?
No, there's some from January and some from December, I believe.
Okay, there must be some other cases I don't have.
Okay.
There's a violation of protection order from February 26th, domestic violence from January 29th, a resisting arrest from February 26th. So he's building up quite a number of allegations here. So we believe that to protect everybody, that there needs to be a cash or surety bond of $5,000 and a protection order.
There was one of me to go to OGP.
Yes, Your Honor. I would like to recommend Mr. Davis for inpatient treatment. My problem is, I don't know if he's been drinking, and I'm not comfortable putting him in residential treatment with the possibility of alcohol withdrawal. It's too dangerous.
And so we had attempted to complete an assessment before he got called up, but he wasn't really willing to do the assessment because he said he wanted to continue with outpatient. So we weren't able to complete the assessment.
I just don't know what to do.
If you want to talk with him?
I should probably give him a call. You could ask him to hold him out of
Okay.
in the front. I appreciate it.
You folks can stick around if that happens. We'll recall you after you talk to your lawyer, Mr. Davis. You're welcome.
State of Ohio versus Samantha case Gonzalez, case number CRB 24-115 A and B. Crystal Gonzalez is on deck.
Ma'am, are you Samantha Gonzalez?
Yes,
Can you hear me, Ms. Gonzalez?
yes.
I'm Judge Capper. I'm at the Lawrence County Municipal Court in Chesapeake. This is your arraignment hearing. You have a right to remain silent. You don't have to say anything. If you do make statements, they can be used against you. You have a right to have a lawyer appointed, if you can't afford one, to have bail and to make the state prove this charge against you beyond a reasonable doubt. You understand those things?
Yes,
The charge is theft. It's alleged March 9th in Fayette Township. You tried to deprive Walmart of property without their consent. It's a first-degree misdemeanor. Maximum penalty is 6 months in jail and a $1,000 fine. Do you understand what the charge is?
yes.
Do you understand your rights? How do you plead?
I plead guilty.
Guilty means you're admitting it's true. You waive your rights to a trial and a lawyer when you enter a guilty plea. You understand that? Okay. Before I sentence you, I'm going to order that you do a urine screen there at the jail so I can see if there's a substance use problem before I decide what your penalty should be. So we'll have them do a urine screen, and then I'll have you back on camera to finish your sentencing after that.
State of Ohio versus Crystal Gonzon, case number CRB 23604 and TRD 193957 A and B. Justin Hackworth is on deck.
Well, this is Mr. Morford's case.
Guess he didn't bother to look at the list.
She was supposed to go on treatment on Friday, but
I know, she was argumentative.
yeah.
So she got to spend the weekend in jail. Do you want to go to treatment now?
I'm sorry.
You want to go to treatment?
Yes, sir. I really did well at BP. I thought that's the other reason I was argumentative, because I really, I think they would say the same. I wasn't being argumentative, but whatever you want to do.
Okay, I think you need more extensive treatment than that now. Are you requesting ankle monitor? Okay, I'm going to release you to Bethesda for treatment with an ankle monitor, and we may have had this conversation or started it Friday, I don't remember. If I put an ankle monitor on you and you leave and cut it off, you just graduated to prison. Okay.
Your Honor, if I may, she needs to make sure her ankle monitor gets charged.
Oh, that's right. She had an ankle monitor before and she refused, that's the allegation, refused to get it charged, or she complained that roommates took her charger. I mean, this is really...
She was having a hard time keeping it charged. I think there was an issue with the charger or something like that, and then she came in here, I'm assuming just to have it checked, and wound up in jail.
A girl had stolen her charger, played a prank, and she didn't know that when you tighten it, that it messed up my cord.
We'll make sure she keeps it charged. They call me pretty quickly when they're running dead.
Okay, well, my understanding wasn't like a one-time call saying, hey, you need to, it was repeated problems.
I had a phone call from her.
Before treatment,
And when she was there and it was going off.
During treatment, I've kept it really well, so for that time, it still was my responsibility to keep it cool.
Okay, I'm going to order you released to Bethesda with an ankle monitor. So we'll have to get that placed through adult probation and then come back on the 22nd for your next hearing here in the court.
All right, I'll be there to get her as soon as I get one on. Thank you.
Thank you.
Thank you, Your Honor.
Thank you.
You're welcome.
State of Ohio versus Justin B. Hackworth, case number CRA 23613.
All right, sir, are you Justin B. Hackworth? Mr. Hackworth, can you hear me? Mr. Hackworth, can you hear me?
Yes, sir, I can hear you. Can you hear me?
I can now. I think it was-
Okay, sir, I can hear you perfect.
Okay, good. I'm Judge Capper. I'm at the Lawrence County Municipal Court, which is located in Chesapeake, Ohio, and that's where your case is filed. And you're actually appearing in the courtroom today on a monitor, and everything you say and your image is being recorded, so you don't have to say anything. You can remain silent if you wish. You have a right to have an attorney, to have one appointed if you can't afford one, to have bail, and to make a mistake, prove the charge against you beyond a reasonable doubt. You understand those things?
I do, sir.
The charge filed against you is theft. It's a charge is a felony of the 5th degree, and it alleges that in the village of South Point on October the 1st of 2023, you purposely took property that belonged to Gregory Thomas, and that property was worth more than $1,000, but less than $7,500. Because it's worth more than $1,000, that makes it a felony 5. Maximum penalty is a year in jail and a $2,500 fine. Do you understand the charge filed against you?
I actually don't, because the written out statement from the deputy sheriff, it states that it says around $1,000. Like, it doesn't state that is how much it was, or there's not like an official document saying how much it was altogether. It says I had $447 on me, and that was given back to the deputy sheriff. And it says I had spent around $300. So that only adds up to $700, and I don't understand why this would be a felony. Because it states that it has to be $1,000 or less than $7,500 for it to be a felony.
That is correct, and that's one of the elements the state would have to prove. If they can't prove that, then it would drop down to a M1 misdemeanor theft, which is the maximum penalty for that, 6 months in jail and $1,000 fine. So that would be part of your defense, could be. Do you have the money to hire a lawyer?
No, I don't. And the name on this is incorrect too. His name is not Thomas, it's not Greg Thomas, so they have his name incorrect also.
Okay, what is the correct name?
His last name would be Thompson.
Okay, Mr. Hill, you can look into that. Do you wish me to court appoint a lawyer for you, Mr. Hackworth?
Yeah, that'd be fine.
Do you have a job?
I was actually about to be hired on for a job before I got arrested, so not now.
So you haven't been working up until now, then?
No.
All right, Mr. Tyler Smith, I'll appoint you. Your lawyer's here in the courtroom, so I'm appointing him. Mr. Tyler Smith's going to be your lawyer. I appointed him. When did you come into the jail, Mr. Hackworth?
Friday afternoon.
Okay, that was the 8th.
Yes, sir.
We can. What's your availability, Mr. Smith?
Your Honor, I'm here this Friday, the 15th. I'm out the next week.
Okay, it's going to be a busy day, but we'll set it for this Friday. Say can be ready. And
This was one that was not on the docket today, and I don't know Mr. Hackworth's first name.
Justin B. Hackworth.
Yeah, we can be ready by Friday.
Okay. All right, I'm setting it for a preliminary hearing this Friday. What's the state's position on bond?
What is Mr. Hackworth's current address?
What is your current address, Mr. Hackworth?
I have two different addresses on different documents, so I have a 272 Township Road address, and I have a 7832 County Road 1 address on both documents.
If you were not in jail, where would you spend the night tonight?
I was homeless, so.
Well, these addresses that you have, are these family members or who?
Yes, The 7832 County Road 1 address is my aunt's and the other one's my mother's address.
Which one would you more likely be located?
Probably my mother's, so it'd be the 272 Township Road, 615, South Carolina.
272 Township Road, 615,
Yes, sir.
South Point.
Yes, sir.
Who's your mother?
Benita Literal.
Okay.
Is there a phone number, Your Honor, that?
Is there a number where you can be reached or your mother can be reached?
740-861-0507.
Is that your mother's number or yours?
That's my mother's number.
Do you have a number?
I have no cell phone number, no. That's how you get a hold of me, with her.
State's position on bond?
We're not opposed to an OR bond, Your Honor.
Okay.
No objection, Your Honor.
I'll set this for I'm gonna let you out on your signature of $2,000. The best thing you can do you know where the court is in Chesapeake?
I do, sir, yes.
Okay.
Yes.
You need to show up this Friday in the morning before 10 a.m. for a hearing, and what's going to happen if you don't show up, I'm going to guess, the state's just going to take it directly to the grand jury. You'll get indicted by the grand jury, and then it'll go to common police court. And since you didn't show up on an OR bond, you probably would never get an OR bond from the common police court. They're going to probably make you post some sort of cash bond after that, or surety bond, and that could mean you're sitting in jail. So if you want to stay out of jail, the best thing you do, I think Mr. Smith would agree with me, is show up for your hearings. And that also gives you the chance, because you're saying, well, maybe this should just be a misdemeanor. This is the misdemeanor court. If you want to try to keep it here, also the best thing to do is show up and make that defense. Otherwise, it's going to go on to the felony court, and then you take a risk of going to prison if you mess up too much, because this is a felony you can go to prison over. You understand that?
I do, sir.
Okay, so that's really important. So, I guess you'll have to show up here at court to speak with Mr. Smith, because there's no way he can get in touch with you between now and Friday, right?
Just that phone number, my mother's number, that's about the only way you get a hold of me.
And are you going to be staying with her until Friday?
Possibility, yes.
Okay, if she'll let you?
Yes.
Okay.
If I don't get in touch with him, then I'll see him Friday at court.
Okay.
That's also fine.
All right, next hearing, March the 15th, 10 o'clock.
Thank you, Your Honor.
We have 4 more today, so we're not ready to recall those yet. So we're here at the court, State of Ohio versus David L. Mills, case number CRD 23758, CRA 249.
Mr. Smith's case. Is it RRS? Yes.
Just take care of
It's a very good report.
it is.
Good job.
Thank you.
Did we take off your monitor?
He's still, asked me to ask that, Judge. It's still on. I think he's doing well.
Yeah, he's doing good.
Yeah, I'll order it removed.
Thank you.
Thank you, sir.
Thank you for doing so well.
Appreciate it.
I think you're on the right track.
Yes.
But maybe I don't have all the information. Let's get whatever other information.
I was speaking to Mr. Smith, did you?
Order that one.
Just for a second.
What input is there from the state?
Your Honor, speaking with Ms. Hoffman here and just trying to gather some information. Our position on this continues to be that we're not, this is not a situation where we're saying we'll dismiss the charges if he does well. We're happy he's doing well and hopefully getting to the root of the problems, the root of the issues that have caused the problems. But at some point, we need to discuss the resolution to this. We've received some additional information today from Ms. Hoffman that will, it goes to the charges, some video evidence and audio. So we'll be passing that on to Mr. Smith. And I would say at the next hearing, we need to discuss whether we're going to need to have a trial. This disrupting public services in particular, it's a felony charge, and it happened during the same incident as the domestic violence. So we do have the option of taking it to the grand jury. This is a serious case.
Judge, we want to keep it here if at all possible, and it sounds like he's doing everything he's supposed to. He did ask me about, can you get his birth certificate, social security card, personal items?
Birth certificate, social security.
I still really didn't get a lot of stuff.
You know where it is?
My coin collection, it was all in that tote that, that came without it.
Like a Rubbermaid tote type?
No, the, tote.
Big
But
items.
I got it, and with half my everything, half of it was missing. Like, I didn't get half my stuff. Some very expensive watches that was my grandpa's. And I got it like a week last month.
It's our understanding that things are not going completely as we would want them to go, particularly in the area of Mr. Mills attempting to get messages to Ms. Hoffman through third parties. And apparently the counseling agency maybe has been made aware of that and kind of told him he better knock it off. Do you know about that?
No, I don't know about that, but I can check into it. I can show my phone, there's no messages to her.
Well, it wouldn't be to
I'm
her.
not
It's
to a third party.
apparently to
No,
neighbors.
no way.
So we want to make sure that we don't have any more of that, because that would have a big impact on how we want to address it.
This is correct. I'm not trying to contact.
Okay, well, just in the future, nothing,
Yes, sir.
no communication. That's what she asked for, and she's entitled to that, so.
Yes, sir.
So when do we want to come back?
About a month, Judge. I'm here the 8th, 15th, 19th of April.
Mr. Gill?
It's better for the court to talk about.
We don't want to go too far out.
Well, I'll do the 29th.
29th.
I can do that.
Ma'am, do you have any input as to what, like Mondays or Fridays, what's better for you as far as coming to court? You okay? The 29th of March is the day we can do it.
I can do that, yes, Judge.
Okay, we'll come back then. Next hearing, March 29th.
Okay. Thank you, Your Honor.
You're welcome.
State of Ohio versus Joseph D. Whaley, case number CRA 2410, CRV 23521, A CRB 23-419, CRB 17-170, CRB 17-133. Mr. Steyer. Might be on the phone.
I'll go back to that.
Let's pass it. I think he's on the phone.
I'm back.
Come out.
Who are we on, Your Honor? I apologize.
Joseph Whalen. Have you had the call on the other case?
No, that I'm aware of, no. And Mr. Whaley, I have not seen this morning.
Your Honor, you ordered him for an assessment, and he didn't show either.
All right, he's got a phone.
Do a discovery update on this one too.
Oh, this is a weapon under disability, we have 3. Oh, listen, I remember this guy now. He was rather agitated. He was the one that provoked the guy that had the outburst in the courtroom last.
Who doesn't show up?
So, you got this one felony and some misdemeanors, so what's the state want to do with it? You want to keep him here with a warrant, or be very happy if you want to send him on to come, please? He's difficult to deal with.
I think he has a number of cases that would remain here too, though.
I agree with that too. On the weapons under disability, we'll nolly that to the grand jury.
So you have a warrant from both. We can have that knowledge to the grand jury, and then I'll issue warrants on the misdemeanor cases that are in this court.
Thank you.
These were OR officers. He doesn't have any bond posted.
State of Ohio versus Casey J. Jackson, case number CRB 22-510, CRB 22-165, A and B, 7th Century.
Your Honor, it's my understanding that Mr. Jackson is reporting this Friday to the Lawrence County Jail because he'll be going to Star on Monday. It's his common police court case.
He's been at RRF.
Yes, Your Honor, he's compliant with the treatment recommendations.
Okay. We've been, this is on a 4th-degree misdemeanor domestic, it's very old. How's the state want to proceed?
Since he's been sentenced in common police court, and we have had this case since August of 2022, he actually pled guilty. So this has been on sentencing.
Right.
We would not oppose that if a jail sentence is imposed in this case, it would be concurrent with his common police sentence and concluded with that.
All right, Mr. Jackson, anything you wish to say?
No.
No?
Good.
Okay, 22-510. He's already pled guilty, so I will accept that. Since he's going to Star, I won't impose a fine. I'll order to pay the court costs, 30 days in jail, and it'll run concurrent with his sentence in STAR. What is the charge in that common pleas?
I think it's a vandalism or something like that.
Okay. I'll set a review hearing on this domestic for September 9th. He should be out of STAR by then.
Hopefully.
In 22-155,
2265, you said?
165, yes, 165.
Bless you.
Excuse me. I'll set it for September 9th for review. It's already been right on that. 22-25-95 was a traffic matter, and I'll just complete it by the jail time he's getting for STAR. So you won't have to worry about taking care of it. So it's done. The other two are set for September 9th. Okay, good luck.
Thank you, man.
You're welcome.
State of Ohio versus Danny Blankenship, case number TRD 192357.
This is set for sentencing. There's a bond up now. So you just have to pay on your fines. Can you make a payment on your fine today?
I want to pay it in full.
Today you are?
Yes, sir.
Okay, here's what I'll do. I'll set another hearing, April the 12th. If you've paid it before then, you don't have to come back. It'll be completed.
Oh, okay.
So it'll be on the sentencing docket April 12th, but pay your outstanding fines and costs, and you don't have to come back. It'll be finished.
Just pay the guy outside here?
To the right, to the clerk's office.
Thank you.
You're welcome.
And I don't have, we're done?
You don't have to come back. If you pay
Thank you,
everything,
Your
it's
Honor.
owed. You're welcome.
Thanks.
State of Ohio versus Samantha K. Gonzalez at the Lawrence County Jail.
All right, ma'am. I've got your urine screen and it was negative, so that's a good thing. Anything you want to tell me before I send you?
I couldn't hear you, sorry.
I got your urine screen and it was negative for any illicit drugs, so that's good. I'm going to go ahead and send you. Do you have anything you want to tell me before I send you? No?
I saw my film, my babies.
Yeah, you're going to get to go home. I'm going to send you, let me see what you were. Okay, $100 fine, court costs, 10 days in jail, suspended. You're ordered to stay out of Walmart. Two years of level 5 probation.
Okay.
And you had a trespassing charge, and I don't know if I talked to you about this before. I can't remember, I'll just make sure. They charge you with trespassing because apparently you've been ordered to stay out of Walmart's because of a shoplifting in Ashland.
I did think a charge in Ashland, but I thought it was just the Ashland one. I wasn't aware that it was, they told me just the Ashland Walmart.
Okay, I'll dismiss it. But now, let's make it clear. And if you want to shoplift, do not go to Walmart. They will catch you.
And told me don't go to no Walmart. Like, I'm not allowed in any Walmart, so I'm understanding now.
Yeah, I'm ordering you not to go in and this. Anybody listening in on the World Wide Web, do not go to Walmart to shoplift because they will catch you. You should go anywhere to shoplift, but you should especially not go to Walmart because they've got all kinds of cameras in the ceiling and they got store detectives watching you all the time. So, okay, you'll get to go home to your babies, but you can't go to Walmart.
I won't go to Walmart, but thank you, Your Honor.
You're welcome.
State of Ohio recalls Michael Davis at the Lawrence County Jail, case number CRB 24114, CRD 062574, CRB 07652.
Your Honor, our intake was supposed to be calling to complete his assessment, so he should be good to come into OVP as soon as they get that done. I'm not sure if they've completed it yet or not.
Okay.
He indicates that he is willing to go to OVP, so I would ask for an OR bond with a requirement that he be released only to OVP, and a term of his bond be that he remain compliant with OVP. And I don't know, I think the state asked for a protective order. I think multiple times the alleged victim has come in and stated she doesn't want a protective order. She's not here today. I assume that would be her position again. But in the event that a protective order is granted, in the event the protective order is granted, I'm going to...
At some point, somebody's got to say, okay, this is enough. You got to stay away from each other.
And I'm going to warn Mr. Davis that if a protective order is granted, it doesn't matter if she wants you over there, you can't go over there.
He's going to be in treatment anyway.
Well...
And you can deal with, if he starts detoxing from alcohol, that's one of the things you can deal with, right?
Yes.
Okay, because I think that's a good possibility with him.
That's why I reached out to Bree.
Okay. Mr. Hill.
I guess I'm just wondering if a GPS monitor would be appropriate.
I wouldn't say you're wrong for asking for one.
So we're asking, yes.
Okay. I'm going to order him released to OVP with an ankle monitor. So, Mr. Davis, I don't know how much you're comprehending what's going on, because you look like you're still a little under the influence to me, just from my eyeballing you. But this is really, really, really important that you understand this. So listen up. I'm going to put an ankle monitor on you, so we know where you are. So if you leave, obviously, they can come right to where you are. There's no getting away from it, because it sends out a continuous signal. Now, a solution to that is to cut the ankle monitor off. And we've had people do that. Here's the downside for you. If you cut the ankle monitor off, you will go to prison then. Am I telling the truth, Mr. Sire?
I mean, I certainly can't predict anything unless there's a conviction, but if you are convicted of removing the ankle monitor in this county, there's a very good chance you're going to go to prison.
So it's not worth it. I've had several people that are in prison now because they cut the ankle monitor off, and these were people that probably, if they had been successful in treatment, could have got their case dismissed. They went from having no charge, no conviction on their record, to now serving a prison sentence because they removed the ankle monitor. That's how serious this is. And it's going to be out of my control because the ankle monitor gets put on you by adult probation from the common police court. They get really upset when people cut the ankle monitors off, and they charge you with a felony. And from past experience, the judges down there want to make an example out of people that cut ankle monitors. So I've got several people in prison right now who came to this court who cut their ankle monitor. So do not, under any circumstance, do that.
I don't understand, I'm not on probation or anything.
It doesn't matter if you're on probation, you're gonna be on an ankle monitor if you wanna get out of jail.
Well, that's not reassuring. So maybe, here, and I've said this before, I'll say it to you. If you think I'm gonna get in that place there that got that ankle monitor and I'm just gonna be itching to cut that thing off and take off, you'd be better off just saying, nope, I'll just stay here in the jail. Then go take the risk that you're gonna cut the ankle monitor off and go to prison.
When will I get that off of me?
I don't think this is gonna work.
I'm saying, when does the ankle bracelet come off? After so long?
After you've completed treatment and show that there's not gonna be further problems, would be, there's not a time, I can't give you a date on that, no one can give you a date on that. You understand that you cannot tamper with the monitor?
I understand.
Okay, next question. Will you be tempted to tamper with the monitor and cut it off and leave?
No.
Okay, I've never had anybody else say yes, but you know what? I've had a few do it. So, if you're an adult, you get to make this decision, but it's a really, really important decision to have the ankle monitor put on. And I don't think, a lot of times people don't realize it, you know, how serious this is. I know, who was the one guy? He didn't even believe me. He thought I was
Corey Little.
Corey Little.
Yeah.
And the thing with Corey is I told him he was going to get 3 years. He got more than 3 years.
6 or 7.
And the problem was he had other stuff. I didn't
Right,
know.
a number of his other charges that would have gone away if he had just stayed in treatment and completed treatment, those charges would never have resulted in convictions, resulted in additional time.
Yeah, so I think he got 6 or 7 years, and I was telling him he was going to get 3 if he took the ankle monitor off. I think he stayed in treatment for a week or something like that, or for what he found.
It was like 2 days.
2 days. So now he's in prison, he's in the Ohio prison system for years. For years. Because he didn't believe me, I guess. I don't know. I guess that's the difference between me and Corey. I would be scared to death to cut the ankle monitor off. He wasn't. And then he just rather go to Argentina or someplace like that, where there's no extradition treaty. Where did he go? Huntington. Went to Huntington. Was hiding out in Huntington. If you're going to do it, Mr. Davis, if you're going to cut the ankle monitor off, you need to head south, against the flow of all the people that are coming this way. You need to go the other way. Where they're coming from, that's where you need to go, because you need to go to one of those countries that won't extradite you back to the United States, because there's any other country in the world, they're going to extradite you on a felony back here. There's nowhere you can go. Okay, so I think I've communicated as much as I can how serious this is. So I'm awarding him release to OVP with an ankle monitor. I'm sorry? No, he's going to
OVP.
OVP.
When do I go there?
As soon as they put the ankle monitor on you.
Hopefully that'll be today, but it's not always the same day.
And can I get a copy of his court order?
I need some kind of medicine, I'm sick.
But they'll help you with that.
That's why we're sending you to OVP. You're detoxing off of alcohol. And maybe other stuff, who knows, but I was serious. Which is dangerous stuff. Okay, let's come back. I think we need to come back with him the 22nd. I think you're already here.
I'm here that day, Your Honor, yes. Are we going to vacate the date of the 4th or the 5th of April and just move everything to the 22nd? I think that keep everything together.
Vacate everything March 22nd.
And we have information on Mr. Earls now too.
Okay, good.
Your Honor, we are waiting on urine screen results for Justin Bates and Charles Hall at the jail. We don't have those yet.
Okay.
Thank you, Your Honor.
Thank you, Your Honor.
We can do Wesley Earls.
State of Ohio versus Wesley A. Earls, case number CRB 2497 and CRB 2488, A and B.
Your Honor, Ms. Dalrymple has spoken to ARC. It's our understanding that if he improved significantly over the weekend, if his level of, I guess, behavior improvement remains, they anticipate releasing him on Wednesday, and that would just be a release.
Okay.
At this point, they questioned whether he'd be allowed to go back to his apartment, and I said, well, I didn't, my position is that unless the court enjoins him from going there, he's able to go there, and so that's going to be up to you. My position on that is that since none of the victims live in the apartment, I think what would be appropriate would be to allow him to go home with an understanding he cannot interact with the one victim. Actually, there's only one named victim who lives in the apartment complex. But if there's any further problems between now and Wednesday, I would assume that we would then be in a situation where he would be placed in like a longer term facility. The advantage we have if he comes home Wednesday is that we can maybe get back in front of the court Thursday or Friday and have something scheduled for him to speak to court clinic.
So what's going to happen to him? First of all, I mean, I'll hear from Mr. Hill, but my thinking is I don't see how I can prohibit him from going back to his apartment. I can give a protection order, no contact order, to stay away from the victims. But what's going to happen when he gets released? I mean, I don't think they're going to transport him.
No, I assume he's just going to be turned loose and over in Kentucky somewhere.
That's it. Belmont.
And that may be something we might be able to make. I hate to volunteer somebody. We might make arrangements through Ms. Gabbard for somebody to go pick him up again. Is she back?
Yeah.
Oh, yeah, you're back. Okay. I didn't see you yet today. So I knew you were in like Florida or something last week.
Yeah, I'm back.
Again, I hate to volunteer you, but would you guys be willing to make that arrangement if need be?
Yeah.
So we could get him back over here through that process.
I mean, I'd love for him to go to a relative or something, but it's my understanding they don't want him.
Well, his sister is in a lease situation where she can't have an additional person, and there's apparently been some issues in the past between himself and his stepfather, so his mother's house is not available to him. So at this point, I just don't have anywhere else to send him.
I don't either. There is no other place to send him that I'm aware of. I mean, this kind of a hole in our system.
And as far as it goes for the apartment complex, again, I don't want to be flippant about this, but it's been over a week, and if the apartment complex was concerned about the situation, they could have filed for an eviction, and apparently, as far as I'm aware, they haven't. So it would have been filed in this court, because the incident happened at the apartment complex, which is in this court's jurisdiction, so as far as I'm aware, they haven't filed for an eviction, so apparently they're willing to have him back.
Mr. Hill.
Yeah, and I don't know anything about whether there's been an eviction filed. It would be our preference to have a situation where he was not placed back in that situation, both for the sake of the people who are the alleged victims in this, and also for Mr. Earl's sake. He gets back in the apartment in the same situation that he was in when this started, and then we have more problems. That's what I fear happening. I don't want it to happen.
Do you have a guest room?
Also,
do you have a guest room?
No, but you do, don't you?
No, I don't. I don't anymore. I used to, but I don't.
I mean, the only other option I have is order him returned to custody.
Yeah, and I don't like that option either, but at the same time, there's also the issue of if he's been, if Mr. Steyer has suggested his incompetency, then there needs to be an evaluation.
And that can't happen while he's in Kentucky.
But it can happen if he's in custody, because we know where he is. But if he's in his apartment, we don't know that we can get him to the place where he has to be evaluated.
Your Honor, does the court have any evidence of any kind of drug use?
Not that I'm aware of.
No, that's not my understanding of any of the allegations here.
Well, I'm going to go ahead and not make any orders. I don't think I can order him not to return. The only thing I can do is order him back into custody, and who's going to go pick, we're going to go pick him up and take him back to the jail. I'm not going to do that. I'm going to try. Apparently he did live in this apartment for some period of time without there being a problem, and maybe he's restored.
Right, and it's my understanding that, I mean, I'm still not certain what his actual diagnosis is, but the impression I've gotten from his family and is that that his mental health can be managed through medication. Now, that's obviously always a little bit fraught, but if he's been hospitalized for, at this point, about a week, so it's going to be about a week and a half by the time we get him, by the time he gets free on Wednesday, in the event that he gets free Wednesday, which I guess is not 100%. But he's going to have a week of, and they're seeing some stabilization. He may be in a position where, at least short term, he'll be able to manage himself.
Well, I think we should put him on the docket for Friday.
I was going to suggest that at any rate.
And so if he's still at the hospital, we'll know that Friday. If he's out, we can check on him.
Right.
He's within walking distance, I think.
I'm not sure exactly where these apartments are.
Brown Street?
There's no eviction against me.
Okay.
And ARC is requesting a copy of whatever court order is generated here, which I don't know that there's an order going to be generated.
I'll just order that the defendant appear, if he's not hospitalized, that he appear for a hearing before the court on, what is that, the 15th?
15th.
And that he is released from jail custody on an OR bond, and I'll put this in there, that he is to take any prescribed medications that are given to him.
It might be worthwhile if a protective order has been, I don't know if a protective order entered in this.
And that there is a protective.
Yeah, that could be maybe nice to have in that order as well, Your Honor.
Yes. And we can send that, if you can get an email or fax or something from them, we'll send them a copy of that order here this afternoon.
Okay. Thank you.
He would have to sign that order.
Why would he have to sign? There's already a protection order, isn't there?
I don't know that there is.
I don't think that.
Oh, God, I thought one had been entered at the beginning of the
I don't
case.
think it was, because I don't think, well, we could have entered one, but I think he was at the jail.
He was at jail and wasn't really in a state to sign one, honestly.
No, I take that back. Here's one. that
Okay.
was
So just a
filed.
reference to the protection order would be fine, Your Honor.
Okay. I guess this one needs to go on my desk too. It's got some follow-up work to do.
Your Honor, just been informed that with Charles R. Hall Jr. and Justin Bates at the Lawrence County Jail, they still have not provided jury screens.
Wednesday.
We have
Okay, we're going to go to that, and then if they haven't provided screens within, I'll just continue this case until Friday. You might want to convey that to them.
State of Ohio versus Brian P. Smith, case number TRC 231421, A and B.
It's Mr. McCown's case, evidentiary hearing on motion.
That's correct, Your Honor.
I see a motion to suppress, a motion in limine. So what's at issue?
Your Honor, we alleged several things. First, that there's been no evidence that the machine was, that the initial basis to stop, that the LiDAR had been calibrated and tested in accordance with procedures. But beyond that, Number one, that Trooper Beam did not have a reasonable suspicion to move from the personal contact phase over into SFSTs, that the SFSTs weren't done correctly. And then there's also, at the conclusion of the SFSTs and after the portable breath test, or excuse me, the preliminary breath test had been administered, there's a statement by the defendant that he had consumed alcohol, and we believe that that should have been a Mirandized statement. So we've asked for suppression of that.
Mr. Young.
Well, we're aware of all those issues, Your Honor, and we're prepared to address every one of them. The one of them that Mr. McCown didn't mention is the allegation that we would not be able to prove that we had the authenticated records showing the ongoing, I don't know what you call it, calibration and testing of the testing device, the breath testing device. And we subpoenaed all those records from the Ohio Department of Health as it almost seems like a make work kind of a thing, but I believe that the contention is that we can't produce these records today. We've produced them and provided them previously, so I don't think there's any challenge to them today. And I believe
that is correct, Your Honor.
And we can admit them, I believe they're authenticated without other authentication. So we're going to do that.
They have previously done that, Your Honor. He is correct. That's why I didn't bring that up for today's
I
purposes.
have those marked as State's Exhibit A, and they're being moved to be admitted as self-authenticated. There's no objection from the defendant on that, as I understand.
Right, Your Honor?
Yes. So, Exhibit A is admitted. Wish to call your first witness.
Your Honor, we'll call Trooper Bean.
Trooper, if you'd raise your right hand, swear you in. Do you swear the testimony you're about to give shall be the truth, the whole truth, and nothing but the truth, so help you God?
I swear.
Good afternoon, Your Honor. Good afternoon.
Trooper, state your name and where you are employed.
Trooper A.J. Bean, the Ohio State Highway Patrol South Point Post.
Were you on duty with the Ohio Highway Patrol on October the 2nd, 2023 at 12:42 in the morning? And at that time, did you come into contact with Brian Smith, Brian P. Smith?
Yes, sir.
Were you on US 52 in Perry Township here in Lawrence County, Ohio when that happened?
I was.
Was Brian Smith operating a vehicle?
Yes, he was.
Do you see Brian P. Smith in the courtroom today? And if you do, can you point to him, please?
Yes, sir. He's seated next to Mr. McCown.
Record show he pointed.
So you were on patrol duty, is that right?
Yes, sir.
And what drew your attention to Brian Smith originally?
I was observing speeds of vehicles around Northwest 14. That's close to, it's just west of Grandview Avenue. If you're familiar with that on US 52. I saw a vehicle coming toward me. It was by itself. There were no other vehicles around it. I estimated it to be a very high speed for a 55-mile-an-hour zone. I estimated the vehicle speed to be at 90 miles an hour. I checked the vehicle speed with my LiDAR device, or laser, that other people will call it. And I got 3 checks on the vehicle, 87, 87, and 85 miles per hour. So I pulled out behind the vehicle as I was catching up to it. So I had its tailgate down. I initiated a traffic stop. The vehicle pulled to the right side of the roadway just before Grandview Avenue.
So let's talk about how you determined his speed. You stated you made an estimate first?
Yes, sir. That's the way we're trained and instructed. Starting in the academy, there's 3 parts to estimating speeds. speed measuring. So the first part is estimating the speed, having a visual estimate. That way, if there's multiple cars around, you need to be aware of which car is moving the fastest, which one you're actually checking, and that way you know that if whatever readout that laser or LiDAR device gives you is consistent with your own visual observations. There are, that's the first part of it. Second part is once I activate my LiDAR unit, I need to hear the target acquisition tone, which is a tone that lets me know that it has successfully captured the vehicle speed. And finally, the third part is looking at the LiDAR unit's speed that it registered the vehicle at.
What's the speed limit there where you were observing Mr. Smith?
55 miles an hour.
And what speed did you say you estimated him at?
90.
So, significant difference than this posted speed limit.
You know, one of the first things I noticed when I started in the Batavia Post, just east of Cincinnati, people drive a lot faster there. When I first came down to Lawrence County, I was kind of stunned by how many people drive very close to the speed limit. So 90 miles an hour immediately, my estimate of 90 miles an hour immediately caught my attention. That's very fast for Lawrence County especially.
So when you used your laser device, what was the speed?
87, 85 miles an hour, 3 checks. And to get one single check, the LiDAR unit makes, I believe, 9 measurements to get one reading. So it's not that it's just one check is one speed. That LiDAR unit is making multiple measurements before it even gives me one single speed.
So this device that you use, are you given training on this laser device before you use it?
Yes, sir.
And do you know the model, the make of the laser device?
It's the manufacturer is Laser Technology. Their model that we use is the 2020 True Speed LR.
I'm going to show you what I've had marked as State's Exhibit B for identification, and ask you to tell me what that is.
Yes, sir. This is the metric user's manual for the instrument that we use.
So were you trained using that manual?
Yes, this is what comes with the device.
Was your device operating correctly when you recorded Mr. Smith's speed?
Yes.
Objection, lack of foundation.
I'll let him explain.
Yes, there's several reasons that I would have confidence that it was working properly. For one, first and foremost, at the beginning of my shift, what I do, we have a permanent measurement station set up at our post. So what I will do is there's a designated spot that we check our LiDAR unit at, and then we have 2 posts that we scan, each with a known measured distance. So the first post is 50 feet away, the second is 100 feet away. So first thing I'm doing, there's a check that I'll do myself that I'll actually make sure that the crosshairs for the red dot is matching where the LiDAR is pointing. So I can simply do that by moving it over, brushing it over, a reflective surface or a hard surface. So I use those same posts I use to check the distance with to make sure that the crosshair is pointing exactly where that LiDAR unit is focusing on. That way I know that whatever I'm pointing at, it's checking. The second thing I do is I do the delta distance test, and what that delta referring to the Greek alphabet, but specifically with change in. So the first thing I do, the first distance I check is a 50-foot post. It's a known distance. I need to see that LiDAR unit is measuring that at 50 feet. And then the second distance, again, is 100 feet. And then once you complete measuring those and making sure that those are consistent readings from those known distances, the final check is that it will do the delta distance. So meaning the change from your second distance to your first distance. So 100 feet minus 50 feet, that's change in distance, right? So delta, essentially, should be 50 feet, 100 minus 50. I had no issues with that check that evening.
Are these tests that you do at the beginning of each shift?
Yes, sir.
Did you do this test at the beginning of this shift with Mr. Smith's arrest?
Every shift, I've never once had an issue.
You're talking about these posts, are those set up there at your post
Yes, sir.
To perform those checks?
Yes, sir.
Are those tests prescribed here in the manual on
Yes, sir.
page 28 of the manual?
I can look at what page it is, but they are in here, yes.
Okay, but you got paper clips.
Oh, perfect, look at that. Page 26.
28.
Yeah, I was looking at this one too, so.
Well, we'll get to that.
Okay. 20, yes, it talks about the confidence checks there, specifically confidence checks, not calibration checks. I'm not calibrating anything, I'm just making sure it's working properly. So, yes.
Now, are there internal checks that this device does to ensure that it's functioning completely as it's supposed to?
It's the first thing it does when it turns on. It'll tell me self-test, pass, and if it's not, it'll have an error code immediately. Never once had an issue. I mean, my LiDAR unit's fairly new. I mean, the one that I had at this time anyway, so it was sound. Never had any issues with it.
On page 26 of the manual, does it describe the internal checks that it goes through when you turn it on?
Display integrity test. I'm sure I got it right. I think this is more of the, when I do tests, there's a different page, I can try to find it for you, that goes over the self-test specifically. That's okay, no, it's not a big deal. But anyway, so the device does its own checks. As soon as you turn it on, if there's an issue, it has an error code. So I did not have that evening. I'm not sure which page it's on. I can find it.
There's an error code. Can you continue to use the device?
So the manual advises that if you have an error code, turn it off, turn it back on. If it has the same issue again, it needs to be serviced. I didn't have an error code the first time, so page 17. So here it is right here, page 17. It talks about its own self-checks. If there's any issues, how to handle that. I had no issues. It makes it very, it's kind of like the breathalyzer machine. If there's any issues, it's very obvious. It's not something you're going to proceed with. You want to make sure that you're doing these checks and these confidence checks so that you know that your operating equipment's working properly. And I didn't have any concerns with that evening based on those two.
I'm going to ask that states exhibit B be admitted.
No objection.
Be admitted.
Now, during the time in which you interacted with Mr. Smith, was your patrol vehicle equipped with forward-facing audio and video camera and camera with audio and video facing the back seat, and also a body camera?
Yes, sir.
Were each of those working correctly at that time? Did they record your interactions with Mr. Smith?
Yes, sir.
And did you upload those to the Axon system so they can be used in the hearing today?
Yes, sir.
Did you review all those before the hearing today, so you're familiar with them?
I didn't review the rear view facing one, but I reviewed the other two. Or the rear facing one, I guess the in-car camera, there's that.
So after you observed the estimated speed and then verified it with the radar device, not radar, LiDAR device, what did you do after that?
I pulled out to initiate a traffic stop. As I'd already said, of interest, the tailgate was down. There are several items in there. My concern was at that speed, you hit a slight bump, things can shift, so I was concerned about him having lost something. So that was of interest to me. Pulled him over on the right side of the roadway.
I'm going to show you. that Mr. Smith's car in front of you there?
Yes, sir. As I said previously, there were no other vehicles around.
Chevy truck, line controller, Viper, and I
So at that point, were you moving to his car to make contact with Mr. Smith?
Yes, sir.
And what kind of vehicle is that?
Chevy Silverado.
Now, as you were approaching the vehicle, did you notice anything unusual happening there in the truck bed?
So tailgate's down. There's nothing hanging over the edges. I mean, he would later explain that he had transported lumber, but I probably count on one hand how many times we've seen somebody driving down the road with the tailgate down. So still of interest to me.
You know what kind of things those were in there in the bed of the truck?
I don't recall. I really don't remember what was left in there.
Did it look like that they were maybe in danger of sliding on out?
Well, yeah. So like I said, especially at that speed, I mean, if you've ever been in a car, you're moving at the speed limit, you had a nice bump or whatever, maybe in Lawrence County roads, there's no shortage of bumps. So, you hit a bump at 87 miles an hour, things can slide out and shit, yeah.
Yeah, you guys.
Okay, so I do want to ask you, before we go on here, when you encountered Mr. Smith, what did you observe initially?
So he had a cigarette hanging from his mouth, as you can see there, discussed what was going on. As we spoke, I observed that he had watery bloodshot eyes. His skin was oily, which you'll see with impaired persons. That's not uncommon. And then, again, he's smoking, so after kind of a moment, when somebody's smoking in the vehicle, you're not going to capture much of anything at first other than that smoke, and then as wind moves, shifts, whatever it may be, after I talked to him for a moment, I can detect the odor of alcoholic beverage emanating from the vehicle.
As you were speaking with him, did he acknowledge that he was speeding?
He said he was in a hurry to go home.
Tailgate's down, only supposed to be lost something in your travels. That's when you're driving, man. Oh, really? Yeah.
I suppose I had some wood back there when I was
Oh, okay. Hopefully you didn't lose anything. You can maybe step out here and then let us check it out. Yeah, ID registration, definitely citation on this one, right? Pretty fast, 55. Check it, 87. You're good. Where do you live at?
I live in Grayson, but I'm on the way to my uncle's house.
Oh, okay. Last stop before you got home, or?
Yeah.
Okay. Gotcha, thank you. And then whenever you get your ID, it'll be great.
find an impairment, that maybe that was neglected?
Sure, I mean, like I said up front, it's not something that you see every day. I mean, most people are conscious of their property and not wanting to lose things. I'm sure he actually did have lumber back there. It's the point that it was forgotten later when you still have other items of value. Again, I don't remember exactly what they were, but they're valuable enough to carry around and have with you. So it wasn't trash, or just, like you'll see sometimes. It was actual property that was, I would imagine, valuable to him as well. So yeah, that's relevant here, absolutely.
Now, going forward, as we watch this and listen to this video forward, do you ask him if he has consumed any alcohol?
Yes, he said he did not.
And do you perform a version of the horizontal gaze by nystagmus test before you go forward while he's still in the car?
Yes, it's not, well, I can't call horizontal gaze nystagmus because there's no possible way that I can imagine somebody's head is going to be in line with their spine while sitting in their vehicle facing me. However, nystagmus from that point of view is indicative of positional alcohol nystagmus. Alcohol causes positional alcohol nystagmus. So that is of interest to me. If I see nystagmus from that viewpoint, that is still of interest to me. I can't call it HTN, but positional alcohol nystagmus is relevant.
Now, while you were talking with him, did you notice any problems that he might have had maintaining divided attention?
Yes, so as you'll see in the video here in a moment, as I'm asking him to follow the tip of my finger while he's seated in his vehicle, I ask him questions, divided attention skills. He answers the questions, but you'll notice that his speech is broken. I mentioned that in my statement. His speech is broken as he's trying to focus on my finger, simply following my finger with his eyes. You can notice that there's divided attention skills that answers are, it should just be a matter-of-fact answer, and he's having trouble articulating. He's having trouble focusing on my finger and talking at the same time.
What's your phone number? 1600. 1600? Yes. 1600. How much you had to drink tonight? None at all? No. Okay. Mind if I check your eyes just for my peace of mind? Check what? Check your, do you mind if I check your eyes just for my peace of mind? Yeah. You just lean toward me. Just follow the tip of my finger with your eyes and nose on it. You take any medication or anything? Yeah, I got PDA medications. I think how long has it been since you had your last drink? How long has it been since you had your last drink? Last drink? Yeah. 3 days. Alright, man. We'll ask you to step out. Ask you to go think.
So at that point, you ask him out of the vehicle. Now, because of the speeding, the tailgate being open with the items in a vulnerable position, watery, bloodshot eyes, smell of alcohol, oily skin, divided attention issues, did you determine that it was appropriate to conduct standardized field sobriety tests?
Yes, sir.
As part of your professional training for employment with the Ohio Highway Patrol, have you received instruction and are you certified to conduct standardized field sobriety tests as they are prescribed by the National Highway Traffic Safety Administration?
Yes, sir.
The question gets asked about which manual we were trained on. Is that the 2018 manual?
In the academy, I was trained on the 2018 manual. I did receive the 2023 supplements.
So you are up to date on most current testing procedures, is that right?
Yes, sir.
I asked you to review some things for me previously. had this marked as State's Exhibit C and asked
Phil?
you.
May I see
Oh, yeah. It's the 23 manual.
the entirety of the manual?
No, just part of it, which I'll show you.
These are procedures for HGN, as well as, oh, we got the administrative procedures for HGN, walk and turn, and one leg stand instructions, and the validated clues that come along with those in Section 8 of the 2023 NHTSA manual.
And I asked you to compare those with the manual itself. Are these authentic
Yes, sir.
copies? And do you recognize them as the procedures you were trained on?
Yes, sir.
When you prepare to conduct the standardized field sobriety test, are there preliminary measures that you take or questions that you ask to determine whether you can effectively administer those tests to a person that's a subject?
Yes, sir.
What are the things that you address first?
I ask 4 standard questions. You might find some variations among various troopers. My point is to get the information I need. So my question, are you wear contacts or glasses? Who said, actually I don't recall if he said he did or not. I asked him about medications. He told me about several antidepressant category, I believe. And then I asked about overall physical health. Mr. Smith informed me about leg issues, knee issues, somewhere. And then finally I asked about do you have any history of head injuries that cause you present day issues. Mr. Smith told me he had a TBI, maybe from an incident in combat. And so I asked him what lingering effects he has from that today. He said headaches and also other things. I asked him if any of those issues were bothering him at that time. He said no, that he felt fine.
So you determined that there weren't any issues that would prohibit you from conducting those tests with him?
Correct.
I'm going to ask that our Exhibit C be admitted, Your Honor.
No, I don't believe I have. I'm just taking a look at it here. I'm not seeing this arrangement of it, so. I do not have an objection, Your Honor.
Be admitted.
Just like make sure you say your color vehicle, you check out your meds too while you're out here. Get some better. What medications are you taking?
Alexa,
What's that for?
it's PTSD.
Okay, fair enough. When'd you get out?
Huh?
When'd you get out of the military?
2012.
2012?
Yeah.
What branch were you in? You said what? Army? Okay. I wouldn't be lost anything, that's the way it was. I mean, did you miss anything?
I had a quarterback here playing.
Okay.
And I had a dog in.
Okay. Are you missing out there on the front license plate when you get these flashing lights out of your face? It's just hard to see from the car flash. It's about, you know, like I said, I just, for my own peace of mind, so I can take you down the road, but if that's all right. Okay. You scared? If you just stand your feet together like mine are there, hands down on your side, perfect. Don't move your head or neck, anything like that. What's the flip my head? Okay, your contacts are glasses.
Did you conduct any horizontal gaze nystagmus test?
Yes, sir.
I would like for you to tell the court what is horizontal gaze nystagmus.
It's the involuntary, well, nystagmus is the involuntary jerking of the eyes. Horizontal gaze nystagmus is it's one of the things we look for as part of the testing regimen that comes with NHTSA standard of sobriety testing. So first thing we do is we want to look for any abnormalities with the eyes. So I'm looking, this is in the administrative steps that come with HGN. I need to be checking for equal pupil size. I need to be checking for resting nystagmus. I also need to check and make sure that those eyes track equally. There are no issues observed for Mr. Smith.
What is the purpose of that? What relevance does that have as to whether a person is impaired or not?
So there's 3 drug categories that are known to cause involuntary drinking of the eyes when you're considering HGN or horizontal gaze nystagmus. Those 3 are depressants, inhalants, and dissociative anesthetics. Alcohol is a depressant, so therefore it can cause HGN, and that's the significance of that. There's 6 different clues that we're looking for in that test per NHTSA's manual and the validation study, or the validation study done for the testing. Observing 4 out of 6, there's an 88% likelihood that that person had a BAC of 0.080 or greater.
I would like for you to explain how you conduct tests step by step, and if you could, also demonstrate what you're doing.
Sure. So there's a preliminary question to help you better understand the individual's situation. We talked about that. Then I'm checking for a bit of pre-test and making sure that there's no abnormalities observed. Again, I've already talked about that. Then I move into actually checking for the 6 clues of impairment, validated clues of impairment for HGN. First thing I'm looking for is lack of smooth pursuit. So as I move that stimulus, are his eyes tracking it equally? In this case, they were not, both eyes. So 2 possible clues there, because there's 1 for each eye. At this point, I observed 2 clues out of 2 being checked for. I then move on to distinct and sustained nystagmus at maximum deviation. So essentially what I'm doing is I'm holding that stimulus as far out as I can where they can still focus on it. And from there, while they're focusing on it, the eye, if it's present, the eye will try to jerk back to the center. That was also observed in both eyes. As I held that out maximum deviation both times for both eyes, Mr. Smith's eyes were involuntarily jerking. So, out of 4 clues being checked at that point, I observed 4 clues. And then finally, onset of nystagmus prior to 45 degrees. What I'm looking for there, I'm looking for nystagmus prior to holding that stimulus out 45 degrees out from his vision. So simple geometry and knowing that if I'm holding that stimulus 15 inches from his face, I'm looking for nystagmus prior to moving it 15 inches to the side. Again, I did observe onset of nystagmus prior to 45 degrees in both eyes. So out of 6 clues checked for, I observed 6 clues. Per the administrative steps for HGN, you'll total your clues. I knew that I had 6 at this point. The final step is to check for VGN, vertical gaze nystagmus.
Before you move on to that,
Sure.
I would like for you also to explain the steps, or the instructions that you give to a participant, to a subject of the test.
Simple is the best. So what I'll say is, hey, don't move your head, neck. I just want you to follow the tip of my pen with your eyes and eyes only. I always use a pen. And I even click it out to where they can focus on the very tip of it. That's what I do. Hey, don't you move your head and neck, just follow the tip of my pen with your eyes and eyes only. Do you understand? So.
In this case, did you follow the procedure that you described earlier with respect to actually performing the test?
Yes, sir.
And as far as the instructions, did you provide instructions and the performance of the test in substantial compliance with
Yes, sir.
NHTSA standards?
Yes, sir.
I'm going to ask you what is marked as Defense Exhibit D and ask you to identify that document.
This is the first page of the HP 70B, or another way, the hair driver report that I completed as part of the arrest of Mr. Smith.
What is the function of that document?
The first page is a summary of what's happened and also documents clues that were observed in each test that was conducted as far as validated clues go.
So does it have, does it record the observations that you made on the horizontal gaze nystagmus test in this case?
Yes, sir.
And what does it show there?
That I recorded having observed 6 out of 6 validated clues, and that I did not observe vertical gaze nystagmus.
So you mentioned vertical gaze nystagmus, and I would like for you to describe what that is.
Vertical gaze nystagmus is nystagmus now moving the stimulus upward as far as that person can still focus on it, similar to distinct and sustained. Distinct and sustained nystagmus is horizontal, vertical gaze nystagmus is vertical, as implied by the title. If you observe vertical gaze nystagmus, that is indicative of it being a high dose for the individual. That does not have bearing on estimating, or not estimating maybe, but we don't consider that when trying to determine the BAC level that someone is at. The only thing the vertical gaze nystagmus is indicative of is whether or not it's a high dose for the individual. I did not observe it. It was not present for Mr. Smith.
Okay, you want to take some less right now?
Yes.
Can you see yourself? Metformin, is that,
Sure.
yes, thank you. Couldn't think of all the time, right? Is that what you think you're taking?
Well, I also take, basically acid reflex, and I take blood pressure pills.
No problem. Would you consider yourself to be a physical health overall?
Not really.
Okay, what do you got going on? Other than,
Well, I mean, I'm obese.
good blood pressure?
I'm obese.
Any like knee injuries, anything like that?
Yes, I got bad knees, yes.
And then any history of head injuries or present-day issues?
Well, I had a TBI.
So what lingering effects do you have from that today?
Headaches.
Okay.
Sometimes like nauseous and like kind of unbalanced.
Gotcha. You dealing with any of that right now?
No.
Like today you're good?
I feel like I'm fine.
Okay, no problem. Only thing I'm asking you to do is keep your head nice and straight. Don't move your head at all. Just have to go all the way to that thing on touch right there with your eyes wide open, okay? This is my bad. Right, turn the signal was right there inside your face. Actually, I have you stand right here. Right there on that light, and you can turn your face. I just don't want that to mess with your vision.
No,
That would be fair. That would be fair to you.
No, I was doing fine.
No, you're good. You're good.
I was doing fine.
Right there, something.
Pause it for a second. So I articulated there a little bit, but just to be clear in case it's not, I realized by, midway through HCN or however far along I was, that I actually saw the flashing of Mr. Smith's turn signal on his face. I knew that he was focusing on my stimulus the entire time, so I knew that what I was saying was HCN, but just to be fair to him, as I told him, I want to make sure that I'm eliminating that from his field of vision. So that's why at this point you'll see me start over now that his eye is not exposed and his turn signal flashing.
Flashing lights or other things like that, can they interfere with the correct reading on the HDN?
Strobing lights can cause, term is eluding me right now. However, it can cause jerking of the eyes essentially. Now, in our training, in the way we were taught, if you're familiar with Josh Kraft, he actually taught the training. What he talked about was, look, if they're focusing on that stimulus, and you're able to tell when they're focusing, there's times when there's people clearly not focusing on the stimulus, we have to redirect them. Mr. Smith was focusing on my stimulus the entire time. And as Josh Kraft instructed us, look, if they're focused on that stimulus, they're focused on that stimulus. What causes the jerking of the eyes when you have strobing lights or something like that is their eyes are focusing on those lights. When they're focusing on your stimulus, that's HGN. That's HGN. So again, I had full confidence in what I was seeing. And I saw it, again, exactly what I saw when he was facing towards the shoulder or away from the highway. Now when I move him and face him toward my cruiser, I'm seeing the exact same thing I saw before. So, one of the things that we get as a part of our standard field sobriety testing is they show us what it looks like when somebody is exhibiting that kind of jerking of the eyes when the lights are flashing. So I knew what I saw, but again, just to eliminate that factor for peace of mind, again, to be fair to Mr. Smith. And that's why you'll see me start over here with lack of smooth pursuit and move on from there.
By the way, during the time when Mr. Smith was performing the horizontal gaze nystagmus test, was he keeping his hands down to the side?
I believe so. I believe so.
Did he continue to follow and focus on the stimulus during the entire?
He focused on my stimulus the entire time. Maybe not in this case. I don't think that there was. There's other, times we're doing a field test. I have to continually be on somebody like, look, I need you to focus on the stimulus. You're not focusing on the stimulus. It's readily apparent. If I move my pen and their eyes don't move, they're not focusing on the stimulus. Mr. Smith was focused on my stimulus the entire time. Optokinetic status is
just a little bit. Same thing, this one here. Okay.
So this is vertical gaze nystagmus here.
All right, there you go. What do you mean?
What was the next test that you performed?
Walk and turn test.
I would like for you to explain to the court what the walk and turn test is, how it's performed, instructions that you give.
Sure. It's a divided attention skill test. So it begins with me having this individual stand in the starting position or try to get them to stand in the starting position. It doesn't always go smoothly. It begins with, hey, if there's not a suitable line, of course there's a white fog line right there on camera. However, I'm not going to have in good conscience somebody stand on that white fog line when this car drive by at least 55 miles an hour. Generally, what we have is there's not a suitable line to use that's safe, so I'll have them imagine a line going from them to a designated point. Usually, in this case, when I had this vehicle, it was I would say something like, imagine a line going from you to the front license plate on my cruiser. Once they affirm that they can do that, I'll ask them to take the left foot, put it on that line. Once they do that, I have to take the right foot, put it in front of the left foot, touching heel to toe. Keep your arms on your side, don't move until I told you to begin. You understand? That is the starting position. Right foot in front of left, arms down to your side, touching heel to toe. While in that starting position, I then give them the instructions for the actual test and how it will be performed. I'm asking you to take a series of 9 heel to toe steps along that line you're imagining, turn yourself around, take another 9 back. You understand so far? Yes, I understand. And I'll continue. All right, I'm going to demonstrate it for you. So you'll be in the starting position as you are, and again, I'm clear right now, just give the instructions that I would if you were right there on the roadside with me. All right, so I'm in the starting position. The test will look like this. 1, 2, 3. I took 3 heel-to-toe steps. You'll take 9. Once you take your 9 toe-to-toe step, keep your front foot touching the ground. Use your other foot to turn yourself around with a series of small steps like I'm doing. And of course, I'm actually demonstrating as I explain the instructions. Once you turn yourself around, take another 9 back. Do you understand everything you've seen? Yes. Okay. Things that you need to make sure you do: keep your hands down on your side, look down at your feet, count your steps out loud, and don't stop till you complete the instruction. Do you understand? Yes. You have any questions for me? No? Okay. You understand the instructions you made? That's the whole rundown.
Now, on this occasion, did you do all those things
Yes.
in accordance with NHTSA standards?
Yes.
And substantial compliance with those standards?
Yes.
What did you observe in this case?
So there's 8, there's 8 validated clues, but already have points of interest before we even started the test. You'll see that it takes some work to get Mr. Smith in the starting position at one point. And I'm sure he really did think this. I didn't think he was trying to be antagonistic or anything. He tells me, well, you told me left foot, front, right. So simple instructions that, hey, if I'm listening and if I'm of sober mind, I should be able to simply understand to put my right foot front and left, hands out on my side. And then, again, Mr. Smith's like, no, you told me left foot, front, right. From there, that was the first observation of interest. There's 2 clues you can observe while they're in the starting position as I'm giving them instructions. They start too soon or they move their feet from the starting position. Mr. Smith did both of those. So of 2 clues that I can even observe before he started, I observed both of them. From there on, there's other clues that I observed. So there's 8 total clues. I observed 7. The only one that I did not observe is that he raised his arms to balance, or used his arms to balance.
I'm going to show you State's Exhibit D as it's been marked. Did you record your observations on the walk and turn test on that document?
I did. So, I record moves feet, keep balance while listening to instructions, starts before instructions completed, stops while walking a steady self, does not touch heel to toe, steps offline while walking, turns incorrectly, or loses balance while turning, an incorrect number of steps.
By the way, according to the NHTSA studies, what is the likelihood that a person has a breath alcohol score of at least 0.08 if they show 2 or more clues on the walk and turn?
Yes, so the minimum is 2 clues. If you observe less than that, basically they're saying 2 out of those 8 being exhibited is a 79% likelihood that person is at a BAC of 0.080 or greater.
Like name, Brian, okay, Brian. Next thing I see you going over here with. You stand right there. Nice to get you around the Facebook corner. What I want to ask you to do at this point, maybe just take a half step to your right. Okay. Perfect. What I'm asking you to do, Brian, is imagine a straight line. Yeah. Going from you to that number 2 that I have in my car there with my flashlight on. Right. Can you see that too? Yes, I can see it. What I'm asking you to do is to imagine a straight line going from you to that 2. Are you able to do that? Yeah. All right. I ask you to take your left foot on that line you're imagining. All right. Left foot. Very good. Yep. And then right foot in front of left, touching heel to toe. Yep. Hands down to your side. Stay like that. Don't move till I said it again. You understand? What I'm asking you to do, Brian, is take a series of 9 heel-to-toe steps along that line you're imagining. Not just yet. I'll say when we begin. I'll literally say the word begin, okay? What I'm asking you to do is take a series of 9 heel-to-toe steps along that line you're imagining. Turn yourself around and take another 9 back. You understand so far? Yeah. Yes, sir. I'm going to demonstrate for you. It's going to look like this. 1, 2, 3. I took 3 heel-to-toe steps. You'll take 9. On that 9 heel-to-toe step, keep your front foot touching the ground. Use your other foot to turn yourself around with a series of small steps like I'm doing. right, here we go. Ready? Nope. I'll tell you when. Once you turn your stuff around, take another yard back. 1, 2, 3. And I took 3 heel toe steps. You will take 9. You understand so far? Yes. All right, you got to get back in that starting position. All right, as you do this, just make sure you right foot in front of left there. You actually got to be in the starting position before you start, just like this. Yeah, you said left first. Right foot in front of left. Yeah, you said left first, but now you're saying right. You want right or left? I said right foot in front of left every time. You already had your right foot in front of left. No, turning left, something like that. Ready? No, I'm not. Right foot in front of left, and that's the way you were earlier, because that's what I said. No, I will tell you when to begin, okay? Go ahead. Right foot in front of left, touch your heel toe. As you do this, make sure you keep your hands down your side. Do it down to your feet. You count your steps out loud, and you don't stop till you complete the instructions. You understand? You may begin. Put down your feet there. Put down your feet. Just like I showed you. Yep. All right, next thing I'm going to ask you to do, Brian, you stand.
Hold on, let it play.
You more done? Okay. That's fine.
Well, I got 10 for you, but
That's fine. I was just asking. I thought you were done.
I'm right-handed, so it's not.
Okay. You can stand with your feet.
Did you do another good sobriety test after that one?
I did, but before we move on, if you didn't catch it, so he stops at 9, pauses, and then as I say, okay, next thing I ask you to do, he takes another step and says 10. And after he said that, I said, oh, I was miffed by it. I said, oh, okay, were you not done? He said, no, I took 10 for you, but because I'm right-handed. That's not a validated clue. Yes, there's a one-liner in the NHTSA manual that says document other points of interest, but I can't overstate how important that is. Just as important as anything else I'm going to observe during this traffic stop. I'm sure at that time, to Mr. Smith, when you're inebriated, taking the 10th step because you're right-handed makes sense, but for a sober-minded individual, that's not logical. Mr. Smith seems like a smart guy. He's a good guy, I can tell you that just from talking to him after the arrest. But that right there is just as important as anything else you're going to see. It's validated or not. That makes no sense. I asked you to take 9 steps, turn as I instructed you to, and take 9 back. As you stop at 9, you take a 10th and tell me it's because you're right-handed. That's just as important as anything else. It's validated.
So the next thing was that the one-leg stamp test.
Yes.
And is that another standardized test that's prescribed by NHTSA?
Yes.
So I'd like for you to explain how that is performed and explain the instructions you give according to the NHTSA standards.
So four validated clues for this test. Exhibiting 2 of those is an 83% likelihood that the person is at .080 or greater BAC. It starts with another starting position, so they'll stand feet together, heels touching heels, toes touching toes, hands down on your side, don't move till I've said it again. And then I'll move into the instructions to take a leg of your choice, left, right, one, doesn't matter to me. Take that leg of your choice, hold your foot 6 inches above the ground, parallel with the ground. I'm demonstrating this as I explain it. Keep your hands down on your side, look down at your toe, and count a series of 1,000 like so. 1,001, 1,002, 1,003, 1,004, and so on until toward the stop. You understand? Yes, you have any questions? Okay. And then I'll keep up my watch, tell them last for 30 seconds. Out of the 4 clues, Mr. Smith exhibited 2. He put his foot down his plate. And much like the last test, I have to correct and say look down as the test is prescribed. I observed 2 out of the 4 clues.
Going back to State's Exhibit D, did you record the results here on this form?
Yes. We recorded it, he swayed, and then he put his foot down.
I'm sorry, which exhibit?
This is the impaired driver report.
I think it's cumulative. It's his testimony that matters, not what that is. I would like to be able to cross-examine him on it as to when it was created and the facts
I'll
around it.
reserve the right to your cross.
What is that labeled as, Mr. Hill?
D.
D, as in Delta, the Greek letter?
All right, so in this case, did you follow NHTSA standards
Yes.
substantially?
Yes.
Gear like mine are, just like that, toes together too, just like mine. Toes together too. You willing to do that? Yeah, we go together, I guess. I was just asking you, that's why I was to make sure we're on the same page. Keep your hands on your side, don't lift outside again, you understand? Yeah. All right, one last deal, listen, Brian, take a foot of your choice, left or right, one, doesn't matter to me, that choice is yours. Take that foot of your choice and hold approximately 6 inches above the ground, parallel with the ground like mine is, both legs nice and straight, don't bend in your knee. Keep your hands down to your side, look down to your toe and count a series of 1000s like so. 1001, 1002, 1003, 1004, and so on. That's how I'm trying to get this out.
Incline like this?
On an incline, if like
Yeah, this is an incline. Every road's got a concave that's incline.
I'm not making you do anything. I'm asking you to. Do you want to do it or not?
No, I'm just saying, I don't care to do it. This, can I turn?
That's probably the most level stretch of 52 in all Lawrence County, man.
Can I do it this way?
If that makes you feel better, that's fine. Do you understand the instructions?
No, I'm cool with it.
Do you understand the instructions?
I'm on an incline for that.
Okay. Do you understand the instructions?
Yeah.
Okay. Do you understand the instructions? You may begin.
Yeah, ready?
Yes, sir.
1 1000, 2
Look
1000,
down to your toe.
3 1000, 4 1000,
That's it. Look down to your toe.
1 1000. Hang on. 1, shit. 1 1000, 2 1000, 3 1000. Okay.
You pick it up as where you left off if you want to.
Yeah, but hang on, my knee is out.
Okay.
My knees are weak. A lot weaker than yours are, trust me.
Okay. I believe you.
1 1000.
Please stop. Can you come out here with me, Brian? You see how?
I would like to ask you there, it seemed as if he'd started to continue doing the one-leg stand, and it was just a short period of time when you ended that test. Was there a reason for that?
My watch hit 30 seconds.
Is that a part of the, what you're supposed to do?
It's a 30-second test, you know, I stick to that, so, you know, if he picks it right up, right after he put it down, it's 30 seconds of time. Simple as that.
Now, after that last test was complete, did you ask him again how much he had to drink?
Yes, yeah.
What was his answer?
He had something to drink after work. I think he put a timestamp, maybe 5 to 6 hours prior to the traffic stop.
I take one more front. My front bumper, please. You have any fires on you in the vehicle? No. I ask you to take a nice deep breath and blow it for me. I ask you to take a nice deep breath and blow it for me. Good. There's got to be more air than that, man. It's like blowing in. Good. All right. Only the action makes some shit last week. Not 3 days, I know that for a fact. Okay, how long ago is that?
Probably 6 hours.
Okay.
All the video that we've shown here today, is that all an accurate representation of the video that was taken during your encounter with Mr. Smith?
Yes, sir.
I'm going to ask that that video be admitted as State's Exhibit E.
Any objection?
The video that's been viewed within in here, yeah, that's, I've got no objection to that. I've got no objection to what we viewed being admitted, so.
You did.
result of everything that you observed from your first observation of Mr. Smith driving all the way to the point that we just watched here, did you place Mr. Smith under arrest for OVI and also speeding at 87 miles an hour and 55 miles an hour?
Yes.
Did you offer Mr. Smith a chemical test?
At the post?
Yes.
Yeah.
Is there a form that you go over with the person that you've arrested for OVI that you go over to advise him of his rights and duties and obligations and protections with respect to taking a chemical test?
Yes, sir.
And I've had this marked as, let's see, was the video E?
Yes.
That this marked as State's Exhibit F, and I'd like for you to tell the court what that is.
Oops, sorry. This is the BNB's form number 2255. It is a form that we're required to read to an individual when arrest is made, and we seek to obtain a chemical test. This is the one I completed for Mr. Smith. It has everything from his information, vehicle information, his breath test that he provided, and all that.
Is that a copy of the form that you gave to Mr. Smith to review and sign that day?
Yes, it is. It's both read and shown to the individual.
Is his signature on there?
Yes, sir.
I'm going to ask that exhibit F be removed from.
Any objection?
No objection, Congress.
Did Mr. Smith agree to submit to a breath alcohol test?
Yes, he was willing to provide a voluntary sample.
And explain where you went to do that.
Our post in South Point has Intoxilizer 8000, and it's connected. It's already been applied, but it's connected to the Department of Health. They get readings to make sure everything's okay. The system itself does checks to make sure that it's within the appropriate levels to determine tank gas, to make sure that it's working properly and that it's registering samples the appropriate level that they are. They're asked to provide two tests. Two tests, it takes the lowest of the two. Meaning if somebody's first test they provide is 0.079, and their second test is 0.082, their official test is 0.079 as an average, anything together, anything like that.
Are you certified to operate that machine and administer tests?
Yes, I've been trained, taken the test, and have an access card provided to me from it.
If you were somehow decertified, would you be able to even get into the machine?
No, there's an access card and a PIN number that I have to enter. You have to be valid to even operate the test.
When the test is conducted and completed, is there a form that is produced from the machine?
Yes.
And is that called an alcohol and drug testing subject test report?
Yes, it has everything from the machine's own internal checks that it's done, as well as the individual's breath sample that they provided. Or if they refuse, it still shows that it's properly working, and it'll say subject refuse test.
Before the test is actually initiated, are there internal checks that the machine goes through to make sure that it's functioning properly?
Yes. And, if there's any issue whatsoever, you want to be able to get it, take a test sample from the individual. Like it couldn't be any more clear that it's not working properly.
I'm going to show you State's Exhibit G as I've had marked, and I would like for you to identify that document.
This is the alcohol and drug testing subject test report from the Department of Health. Specifically, the test sample that Mr. Smith provided. His first test was a 0.135, his second test was a 0.135. So Two tests, BRAC, 0.135 grams per 210 liters.
Who's the testing officer there?
That'd be myself.
So you had to enter certain things in order to be able to access that machine, is that right?
Yes, sir. I have an access card, PIN number, and other information that's provided to the system.
The test was conducted at what time?
1:34 in the morning, so just under an hour from the time of the traffic stop.
Was there anything that was produced by this report that would indicate that the test was not valid?
No. There's different times that different things have triggered an invalid test. I mean, that machine it has to be operating in a very tight, in a tight way. For example, I've had tests, not be valid because it's an improper sample. They didn't provide enough volume, or there's radio frequency interference detected, so it shuts it down immediately. You have to start from scratch. There's no way to have any of those and then still get a test. If there's any issue of any kind, the machine shuts down. You have to start from square one. Even if this happens somewhat often, I'll get one valid test from somebody. They go to provide their second sample, and for whatever reason, it didn't blow, with enough volume or whatever it may be. It's an improper sample. If I want to get a valid test, then I have to start from square one and get 2 more tests from them. So the machine is very regimented on how it, can take a valid test from a subject.
Is this an accurate copy of the test report in Mr. Smith's case?
Yes.
And the test score again was?
0.135 grams per 210 liters.
So that's in excess of the legal limit of 0.080?
Yes.
I ask that the G be admitted.
Objection.
Admitted.
I don't really know what the court's ruling was on Exhibit D. I know Mr. McCown wanted to cross-examine on it, but I want to make sure it was admitted if it's.
I believe the court withheld it until.
I withheld the ruling, but you can use it if you wish.
I don't have any other questions. Oh, I do have another question. Do you recognize Mr. Smith in the courtroom today?
Yes, I identified him as seeing this one. Thank you, Mr. McCown.
Mr. McCown.
Thank you, Your Honor. Good afternoon, Trooper Bean.
Afternoon, Mr. McCown.
I'd like to talk to you a little bit about your training experience in this. You indicated that you were certified in these standardized code industry. Is that correct?
As in, I have a access card. If you're talking about, do I have a certification number?
But hold on. The access cards for the breath testing.
Yes.
Before, when Mr. Gill was talking about standardized field sobriety tests, he asked you if you're certified.
Okay.
To administer these.
Sure.
And you indicate you are.
As in, I have a certificate of successfully completed.
There is no certification, correct?
Sure.
I've had the exact same course that you had in this.
Sure.
I am not certified, you are not certified, but trained and authorized, is that correct?
Certified in the sense of, my understanding is I have a certificate of successful completion of the course. I do not have a certification number.
Okay, and you testified that you were trained on the 2018 manual, is that correct?
Yes, sir.
And I'm a little bit confused because you didn't say you were trained on the 2023 update, you said you received the supplement.
Maybe poorly worded.
Okay.
I have the 2023 manual. They even specifically sent out a memo of the particular changes made to the 2018 manual. So
Okay. Let me ask you this. Have you received the educational seminar on it or the update refresher course on the 2023 manual?
No, sir.
Okay. So, and the reason I ask this is it was our understanding in documentation that's been provided that everybody has been trained on the 2023, but your testimony is you just received the supplement, here it is, and here's a memo. Is that correct?
As well as the manual. I mean,
sure.
If you look at the changes, I mean, we're talking about making things more current or modern, removing things that they considered dated. Those are the bulk of the changes. There's some rewording of the clues and whatnot, but by and large.
But you have not had a refresher course?
I did not go to anywhere to receive an in-person training.
Okay. You said that they provided you with a written memo addressing the differences. Have you provided that to the state before?
No, sir.
Have you been trained for A-Ride as well?
Yes, sir.
Okay. In none of the NISA manuals does it indicate that oily skin is indicia of impairment. Is that correct?
Correct.
Have you ever been told by a physician that if somebody has oily skin, that it's an indicator that they're under the influence of alcohol?
No, but by that same token, if you look at A-Ride, one of the things they talk about is the body fights to get back to baseline. So when you see somebody who's taking a stimulant, it can cause pupil dilation, and the downside effect can be that their pupils become constricted because the body's fighting to get back to the normal pupil size. That's a body reaction. Same token, by alcohol dehydrates the body. Would it not then make sense that the body is, excreting oil?
Okay, and where, in what training was that told to you?
It wasn't.
So you've never been trained on it?
If you're specifically talking about oily skin.
Yes.
So, no, it's not in a training.
Okay.
It's not uncommon, though, to see somebody who's impaired by alcohol.
So let me ask you this, because you indicated, and even noted in your report, that oily skin was an indicator to you that he could be impaired. When have you ever been trained that's an indicator that somebody could be impaired?
So that's one of the things that, when we graduate the academy, we get a coaching session. That's one of the things that our coaches will talk about is, hey, look, this person, it's not manual, but look, take note, when you're dealing with alcohol impaired persons, notice their skin.
So some guy told you this at some point?
Another trooper, yes.
Okay. So
I actually had two coaches.
Another trooper said, hey, this could be an indicator.
I had two coaches, but yes.
Do you know what study they cited to indicate that would be an indicator?
They did not, training and experience.
Okay. So in their experience, hey, we've come across people with oily skin and they happen to be impaired. Therefore, that's an indicator of impairment.
That's the same argument for water and bloodshot eyes. So
we'll talk about that too. But is that your position?
That from my training and experience, yes, that is consistent with alcohol.
So every teenager that has oily skin, by goodness, if you're pulling them over, I'm thinking maybe there's some alcohol going on here.
If you're asking me if I would have arrested Mr. Smith because he had oily skin, I would not.
Okay.
There's a greater picture.
The impaired driving report, Exhibit D that's up there.
Yes, sir.
When was that completed?
So it doesn't have a completion date. I complete those anywhere from 2 to 3 business days.
Okay, so that was not completed contemporaneously with what's going on the video or...
I did complete it the same day, if that's what you're asking.
Okay. What about your officer's narrative? Was that completed the same?
Same time. I do all that same time.
So your training obviously is part of your training to complete these narratives and that they're supposed to be full, complete, and accurate.
Sure.
Is that correct?
Yes, sir.
As a matter of fact, I think one of the slides in the NIST manual says, if you don't write it down, it didn't happen.
I don't, if that's in the manual, I'm not sure.
Okay.
I'm not saying I agree or disagree.
Let me ask you, first on the BMV 2255 form up there, you still have that in front of you?
I do not, no.
Did you take your, oh, sorry. State's exhibits up there. That's it.
What's that, Mark? What's the exhibit number for whatever on it?
F.
Yeah, okay, thank you.
On Exhibit F, over on the right-hand side, you have to list the factors that would indicate reasonable grounds for OVI. Is that correct?
Yes, sir.
You stated that he swayed while standing.
Yes, specifically during HGN testing.
Okay, well, because later on you talk about SFSTs.
Sure.
But so was there any point that he swayed while standing not hitting SFSTs?
No.
You're only talking about the one leg stand.
When I say SFSTs, I'm talking about validated clues.
Okay, well, swaying is a validated clue, isn't it not?
A validated clue for
For the
HDN.
for the one leg stand.
Well, I'm talking about HDN there.
Now, wait a minute. Let's go through here. It says, I requested to know my reasonable grounds for an OEI were watery, bloodshot eyes.
Yes.
First of all, can we go ahead and
Go
put
for
this
it.
to rest?
Yes, sir.
Is watery eye an indicator of impairment under NHTSA training?
It is not in the NHTSA manual.
Okay.
Just like oily skin.
Okay.
Still relevant.
So I didn't notice here. Why didn't you put oily skin here?
There's only so much space.
Okay. Odor, I presume, odor of alcohol.
Yes.
Speech, you did not have slurred speech, is that correct?
I did not have slurred speech.
Is broken speech an indicator of impairment? We'll go more in depth, but is it an indicator of impairment under NHTSA guidelines?
It is not listed in the manual.
Admission of alcohol, we'll talk about that here in a few minutes. And then you have sway while standing and then SFSTs. So you're suggesting that the sway while standing is actually part of the SFSTs.
No, that's what you're saying.
Okay. Why would you separately list them, just out of curiosity?
So when I put SFSTs, that's a blanket for validated clues.
Mm-hmm.
Suede is a validated clue for the one leg stand. I specifically differentiate that there because it is swaying while doing horizontal gaze and nystagmus. That's not a validated clue during horizontal gaze and nystagmus. If you look at my statement, they even articulate that.
Okay.
So let's talk about the statement that you gave.
I want to take you back because you know that, by the way, how long have you lived in Lawrence County now?
Oh, I moved back in 2022.
I said, you said you moved back. You're
Yes,
originally-
I'm from here.
You're from here, you grew up here.
Yes.
You've ridden through the hills like the rest of us down here.
Not so much.
Okay.
Mr. Haslam was able to make fun of me a little bit for not coming to Lawrence County.
It's ironic that Mr. Haslam make fun of you for that. But you're telling me that in your life, you can count on one time the number of times you've seen a pickup truck driving around. On one hand, the number of times you've seen a pickup truck in Lawrence County with its tailgate down.
That's true.
And you're sticking by that.
Yes, sir.
Okay.
Well, okay, let's clarify. Without reason. I've seen tailgates down transporting lumber.
Okay.
That's different. There's no reason to have that tailgate down at that point.
Okay. So your position is if it's not an obvious reason to you, they don't have a reason. And hey, it just doesn't, I can't believe somebody had their tailgate down.
If you see a reason why that tailgate would be down there, please enlighten me.
Okay. So let me ask you on the personal contact. Well, let's start with the validated clues. There are validated cues for determining if there are indicia of alcohol. Is that correct?
Yes, sir.
NHTSA has 7 of them. Actually, they've got 30 for vehicle in motion.
Yes, sir.
7 initially for problems maintaining proper lane position. Is that correct?
Yes, sir.
Out of those 7 cues, how many did Mr. Smith exhibit as he's traveling down the road?
0.
Okay.
It's not required either.
There are 4 for speed and braking problems. Is that correct?
Yes, sir.
Out of those 4, how many did Mr. Smith exhibit?
0. It's not required either.
After that, there are vigilance problems. Is that correct?
Yes, sir.
There are 6 of them.
Yes, sir.
How many of those 6 did Mr. Smith exhibit?
0. It's not required either.
Judgment problems. Is that correct? That's one. There's 7 of them.
Yes. It's still vehicle in motion, right?
Yes.
Yes, sir.
There's 7 of them.
Yes, sir.
How many of those did he exhibit?
0. It's not required either.
Okay. But in all these cases, he's maintaining control. You're saying, well, a high-speed motor vehicle.
Sure.
He's not swerving.
Yeah.
He's not weaving.
Sure.
He's not crossing the center line. He's not gunning over and crossing the fog line. None of those things.
Correct.
After you commanded him to stop, did he respond appropriately?
Yes, sir.
Did he slow down correctly?
Yes, sir.
Recognize that you had come up and you had put on your strobes, take down lights, whatever
Yes,
you
sir.
all, however you refer to them?
Yes, sir.
Turn his turn signal on.
Yes, sir.
Exited?
Yes, sir.
Pulled over.
Yes, sir.
So,
None of that's required though for observation.
pulled completely out of the roadway. Is that correct?
Yes, sir.
All of these things he did like a normal sober driver would do. Is that correct?
He didn't exhibit any of those, yes. Agreed. Again,
Okay.
it's not required for observation.
So out of those 30 cues, he exhibited 0.
Correct.
You then had him stopped, and you stopped him, you indicated for speed. Is that right?
Yes, sir.
And you went through with Mr. Field your testing and how you test the LiDAR equipment.
Yes, sir.
And you discussed the various tests that you do.
Yes, sir.
The fact that there were no error codes.
Correct.
I'm sure when you had an error code pop up, that it says, hey,
Not as a part of the operation of the only time I've had error codes, excuse me, is if it didn't get enough of the test. So I talked about if it's in continuous mode, which is how I run it, it does 9 checks a second to get that speed. If it doesn't get 9 successful ones, you won't get speed back. So that presents an error code. So not having enough tests by the machine, I've received an error code, but I've never once ever had an error code as a part of the self-test as it boots up or when I'm doing my confidence check post.
how long have you had this particular instrument?
I no longer have it, but I'd had it for approximately 1 year, I'd say, at that time.
Okay. Had other officers had it, or troopers, excuse me, had it before you?
No.
This was administered to you only?
Yes, sir, at
Were
that
you,
time.
were you the only trooper that used that particular LiDAR?
Can't be certain of that. You know, sometimes we would leave our cars on post. If somebody needed a car,
Sure.
they could have used it, yes.
So they may have taken it out, utilized yours.
Possible, yes.
And so there's a mechanism that we have, obviously, for tracking whether equipment fails or doesn't when we do those checks.
Sure.
That's called a log.
Sure.
Did you provide your logs for these checks?
If there's a log held for a LiDAR unit, I'm not familiar with it. I'm not familiar with it. So I even had a case recently with radar for calibration, not LiDAR, radar. I emailed the technicians for the district and I asked them for a log of the calibration that they do for both radar and LiDAR. So the High-State Highway Patrol only does calibration testing for the radar unit. They do not calibrate the laser. So it comes verified out of the factory.
But you also indicated you have to run through these other checks on a daily basis.
Confidence checks, not calibration.
Sure,
checks.
okay. And these confidence checks, whether you are using it, somebody else is using it, are important to make sure it's working
Yes.
okay.
Yeah.
You agree? But you're saying no logs are ever kept in these confidence checks?
No, the important thing is it's working properly.
Okay. So let's go to the personal contact cues for NHTSA. There are 12 site cues, is that correct?
I'm not sure the numbers off the top of my head, but I'll take your word for it.
Okay. Bloodshot eyes.
Yes.
When you approached, you indicated that you noticed at some point that he had bloodshot eyes, is that correct?
Watery bloodshot eyes, yes, sir.
So, again, watery eyes.
Yes.
You've heard that from some other trooper that can indicate alcohol impairment?
Well, it's not just heard it, seen it, witnessed
Okay.
it, experienced it.
Okay. Have you ever come across a sober person that had watery eyes?
Sure, yeah.
Okay.
Yeah, absolutely.
You would agree that just because they have watery eyes does not mean they're impaired?
Just like oily skin.
Okay.
Just like oily skin. It's all the puzzle pieces coming together.
And so, in addition,
when you approached him, he had a cigarette hanging out of his mouth, is that correct?
It is, yes.
Cigarette smoke wafting up?
Sure.
Can that cause bloodshot eyes?
I don't know.
Now, you know oily skin can cause, by alcohol, but you don't know that cigarette smoke can cause bloodshot eyes.
I'm not trained to detect impairment from nicotine.
Okay. I want to get you, I want to make sure this testimony is correct. You are testifying that alcohol consumption can cause oily skin, but you don't know if cigarette smoke can cause bloodshot eyes. Is that what your testimony is?
I believe yes, watery eyes. Common sense would tell me yes, it could cause watery eyes.
Okay. What about bloodshot eyes?
I don't know. I don't know. When I think of bloodshot eyes, vasodilation, right? So.
Okay, that's fair enough. Vasodilation, that is, of course, where your blood vessels, allow blood obviously coming out.
Yes.
You can see it.
Yes.
We also call it flushing.
Yes.
Right? Alcohol is a vasodilator. And so if somebody is inebriated, typically, what are we going to see with their face?
It can be vasodilation, as you discussed.
Flush, right?
Yes.
Did you know anywhere in any of your reports here that Mr. Smith's face exhibited flushing or vasodilation?
No.
He didn't have it, did it?
I can't say that. I just didn't make notes.
Well, would you have noted it if you would have noticed vasodilation of his skin?
Possibly. I don't know. It's hard to answer something that didn't happen. I don't know.
You stated, well, as we looked at it, he started looking for, he knew you were going to ask for documents, clearly.
Yeah, it looked like he was shuffling through them.
But he paused to make sure and asked you what you needed. Is that correct?
Sure, but that's not significant.
Okay. And then he continued to look for them. He looked for those documents.
Yeah.
You continued to ask him questions. You were talking to him. Where you come from? Where do you, or actually you asked, where do you live? He answered that. Knew what your next question was going to be because this is the opposite direction from Raceland, right?
Yes, but congratulate him for doing that. So, okay, should I also be amazed that anybody who's drunk can tell me their name? Like, that's not significant.
Hold on. I'm not trying to belittle you. I'm not,
no.
Going through this or trying to beat you up.
I understand.
I'm not suggesting you should congratulate him. I'm asking a question.
No, I understand it. I'm saying your point is that because he did this, he couldn't be impaired. By that same token, anybody who's ever been drunk shouldn't be able to do anything that you're telling me that he did successfully. That's not significant. You understand what I'm saying?
My question is to you, did he go ahead and offer up this additional information in a natural conversational tone?
Yes, but again, it's not significant.
Okay. He did that while he was looking for these documents.
Sure.
At the same time.
Yes.
Divided attention even.
Sure.
Is divided attention significant in this trigger?
Of course, and I have no issues
And
with
he
that.
successfully was completing it here as he's conversing with you about his origin, his location of origin, and his destination while looking for something completely separate and going through documents trying to identify that particular document that you requested. Is that correct?
He did that, yes. That's
He
correct.
did it successfully.
He did it successfully.
Just like a sober person would do.
Sure.
Okay. Now, once he located the first document, which I believe was the registration,
Sounds correct.
he handed that to you. It was a paper.
Yeah, I don't remember the order, but yes.
Okay.
Yeah, that's fine.
He immediately turned back around to start going through the documents to look for his driver's license too. Is that correct?
He continued to look. Again, I don't remember the order.
He didn't pause and you have to remind him. He did it.
Sure.
You state in your statement, in your narrative, excuse me,
while I examined his eyes, so at this point, by the way, you've indicated now, I think you've detected odor of alcohol.
I don't remember, it was delayed, you know, I
Okay.
touched on it a little bit. Cigarette smoke, that's the first one that's gonna grab your attention.
Sure.
So,
The
yes.
urgency of it, the acrid
Yes.
nature of it.
After talking to him for a moment, I did detect there are alcohol beverage emitting from the vehicle.
It's still not enough to pull him out and say, hey, look, we're doing field sobriety, get over here. That may be-
Not just based on odor alone, no.
Okay. So, you would agree, I guess we're starting. Based on odor alone, it's not enough to pull him out, go ahead and put him through the rest of it.
Just based on odor alone, no, I agree.
Now, you then ask him to do this eye test.
Yes.
And which you've indicated, and you're correct, positional mistake, you could not do an HGN test.
Correct.
As you did. And the reason for that is, as he's seated there, he's turned this way.
Correct.
His spine's now out of alignment.
Yes.
And if there's any alcohol in his body, it can cause positional alcohol nystagmus.
Yes.
Whether it's consumption of alcohol or he had any other type of alcohol in his body, it can cause this positional alcohol nystagmus, correct?
Yes.
Doesn't mean he's intoxicated.
Does not, no.
Does not even mean he's impaired.
Does not. I mean, as I'll be the first to tell you, look, hey, there's no validated clues for positional alcohol nystagmus. It's just indicative of alcohol in the body.
Okay. So you would agree then, all that does is confirm your suspicion that there is some amount of alcohol in there. I've already had this odor. He's on one end of it, okay? That's still not enough, obviously, to get him out of the car. I mean, you've already smelled the odor of alcohol. Nothing's changed really at this point as far as your data collection.
All of my observations went into asking him out of the vehicle.
Sure, I understand that. We'll get that. That's
Yeah.
But at this point, just doing that, that's not going to do anything other than confirm what you already smelled.
Sure.
So you've already noted that. So would you agree, hey, we still don't have enough at this point to get him out? It's that combined with these other things that we're going to talk about.
Yes.
Okay. So the next thing that you do is you say in your narrative that I asked Mr. Smith what medications he was taking. He replied, yeah, I got the medication I take, etc. Okay? And you state that I took note of his broken speech while he was doing it. And as a result of all these things, you asked him, these other statements, you asked him to be alcohol. Okay?
Yes.
And part of this is the fact that he had an inappropriate response. You asked him what medications are you taking, according to your narrative. And instead of telling you what medications, he said, well, I take VA medications from the VA, and started talking about something else. Is that correct?
It was, I mean, we played the video, it's broken. It's not, you make it sound more seamless than it was.
Okay. Well, I don't mean to make it seamless.
No, I understand that. I'm just making sure.
But it's also that it was an inappropriate response, not just in the brokenness, that because you asked him what medications he was taking, and instead of telling me what medications they were, that he replied, yeah, I got VA medication that I take. In other words, he didn't answer the question. Mm-hmm. Is that correct?
That said, what are you asking me on how it relates?
I'm asking you, is the fact that, according to your narrative, he didn't answer a question you actually asked, did that factor into your calculus for pulling him out of the car?
It was the divided attention, so you're kind of making my point for me. I asked him what medications he's taking. He's struggling to even tell me not what he was taking, but that he was just simply taking medication from the VA. That's a far easier answer than thinking about all the medications I took and telling me what they are.
Okay. So he took the easy way out and tried to answer something else rather than actually even think of what he was taking. I can tell you.
I don't know what he was thinking.
Okay.
So
let's go back.
Yes.
Again, your narrative You can begin right there while I examine him and tell me what it says. I don't want to misquote you here.
While I examined his eyes, I asked Mr. Smith what medication he was taking. He replied, yeah.
And we can get to the reply, okay? So you just asked me what medications he's taking.
Well, check this, you mind if I check your eyes just for my peace of mind? Yeah. You just lean forward a minute. Just follow the tip of my finger with your eyes not on there. You take any medication or anything?
Wait a minute. That's not what you asked me, is it?
Fair point. Again, the emphasis was not on how he responded, but the way in which he responded. That's, if it's such a simple answer, it shouldn't, why did it take that long to formulate the answer? You understand what I'm saying? It's not the focus on that he answered differently according to my narrative, and I concede 100%, you're right, I did ask him that. The point that I was making in the narrative is that, and I even articulated that in my statement, the divided attention skills. He wasn't able to say, why was there so many pauses, why was there so many breaks in that answer? That's a simple answer.
Well, you, just in your response to me, to my question of, that wasn't what was asked, was it? You just now paused, broken, and changed your response mid-sentence a couple times.
Sure, but I'm saying right here, it's not hard to formulate the answer. Yes, I take medication from the VA. Yeah, I take medications from the VA. Just while following the tip of my finger, that's divided attention issues.
Okay. Nerves could enter into that.
I mean, he seemed pretty relaxed to me.
Just like if I answered, is that what was asked? The simple answer would be no. Right?
Well, I mean, I think you're stretching exactly what's going on. At the end of the day, you're saying it's nerves, but at the same time, he's been calm the whole time. Why did it take that long to formulate that answer?
Okay, so when I just asked you, would the simple answer have been no, right? The simple answer would have been yes.
My job is to articulate what's going on here. I mean, if you want me to answer with yes or no, I can do that.
1600? Yes. 1600. How much you had to drink tonight? None at all? No. Okay. Mind if I check your eyes just for my peace of mind? Check what? Check your, you mind if I check your eyes just for my peace of mind? Yeah. You just lean forward a minute. Just follow the tip of my finger with your eyes not on there. You take any medication or anything? Yeah, I got PDA medications. And I take how long distance you had last year?
So, right there, you said that pause mattered as well, right? He waited until he could look at you. And he looked at you and answered. Is that correct?
Sure, you never answered a question without looking at somebody? That's the whole point of divided attention. That's the whole point of divided attention. I'm asking questions while they're doing something else.
Mm-hmm. And he did everything okay up to this point, up until you got a flashlight in his eyes. Is that correct? When he was going for his driver's license and all the others?
I mean, so which one is it then? You're arguing both ways. I guess I'm confused on what you're driving at here.
Well, and so the great thing is, Trooper Beam, all you got to do is answer the questions. You don't have to get what I'm driving at.
Okay, fair enough.
Okay?
Fair enough.
Is it your testimony that at this point, that's when you decided, after his response to the fact that he was taking medications from there, and then he said, I ain't drank nothing. At this point, that's when you say, okay, now I got enough to get him out.
It's the whole picture, everything I've talked about. So we've got the tailgate. You've got a high speed, or an irregular high speed. And when I say that, I can genuinely say it is rare when I check the car moving that fast. I get up to the window, watery, bloodshot eyes. Odor. I've got divided attention issues. I've got something that's indicative of alcohol in the body. At that point, I ask him to step out.
Earlier, you said we need to take a odor of alcohol. You didn't have enough yet to get him out.
I said that alcohol in and of itself is not enough to ask him out of the vehicle.
Did you have, there are actually recognized divided attention skills that NHTSA teaches, it's true, or that NHTSA teaches and that you're taught.
Yes.
As part of your training.
It's true.
That are not there to score, but are there to determine during the personal contact phase, hey, is there enough? Is that correct?
Not necessarily is there enough, I'm not required to offer that.
Well, but it's to facilitate your investigation.
It can, yeah.
Sure.
Why
Offer that, is that correct?
It seems redundant though to offer that if I've already got examples of divided attention issues.
Okay. So these are, however, are validated tests that you're trained on, correct?
Yes, absolutely.
Okay. These others are things that you've come up with, or learned from other troopers, or just kind of guess at, right?
Yes.
And those are the ones you went by, not the ones you then validated and trained on. Is that correct?
I'm not going to offer a test to confirm something that I've already seen. I'm just not.
You're not getting to offer a test on something you've seen?
I'm talking about the test that you're talking about specifically. I'm not going to go through the whole touching the tip of the fingers and all that stuff in the car to see divided attention skill impairment when I've already.
Even though that's what you've been trained to do?
It's not required, and we're told that in our training.
Before you did any tests, well, let's talk about optokinetic nystagmus just briefly. And that's what you're talking about with that strobing effect.
Yes, sir.
It's not just strobes, by the way. You were trained on the 2018 manual. We also said oncoming traffic, if you have traffic going by nearby, that can cause it. Is that correct?
Strobing, flashing lights.
Flashing lights. As a matter of fact, the blinker, as you noted, could cause it.
Yes, sir.
And the effect of it is this: if there is a flashing light within your field of vision, no matter what you're focusing on, if it's blinking over here, that can draw your focus off of the item. Is that correct?
If
The stimulus.
you're looking at that light.
Well, you're supposed to focus on the stimulus.
Yes.
As you're focusing on that stimulus, if it passes by a flashing light, that flashing light can then draw your eye off, correct?
My understanding of that type of nystagmus is that it comes from actually focusing on the strobing light.
But you would agree that, and it's not just strobing light, the flashing light, but if that's in your field of vision, that can cause your focus to shift over to it, correct?
I would not necessarily agree with that. I mean, if maybe there was an ambulance that drove by with flashing lights, or South Point Police Department driving by with flashing lights, that's a concern.
If you're focusing on me and a clown runs in here, you're probably going to get distracted and focus on the clown, I would imagine. Is that correct? Other than this clown, I think something else.
You're probably right.
Is that correct?
Yes, sir.
You would agree with that? That get distracted and cause a shift of focus.
A shift of focus, exactly.
Okay.
Mr.
Now,
Smith was focused on the stimulus the entire time.
can you talk about this? Obviously, you have to instruct them on the test that they're taking. And would it be fair to say if you don't tell them to do something, you can't score them for doing it?
What do you mean?
I mean, if you say, hey, I want you to hold on a one-leg stand, I want you to hold your leg up approximately 6 inches. If they never do, or if you don't tell them don't put their foot down, if they put their foot down, you can't score them on putting their foot down. Is that correct?
No, I would never tell them not to.
You never tell them hold it up for the entire 60 seconds?
What you're saying specifically, don't put your foot down. I've never
Okay.
told somebody that.
Never told them to put their foot down?
I've never told them, don't put your foot down.
Okay. As part of the instructional phase for the HGN, you're supposed to tell them to focus upon the stimulus for the entirety of the test, aren't you?
I believe the verbatim wording, yes.
Okay. You've got the exhibit up there with the NHTSA manual. If you want to take a look at that, go over to page 25 on that.
I think the judge has it.
Oh, I'm sorry. Read the very last instruction you're supposed to give.
Keep looking at the stimulus until told the test is over.
You did not do that in this case, did you?
Correct. So to the standard of strict compliance, that would be an issue.
Okay. You don't think it's important to tell them to focus on the stimulus for the entirety of the test?
Follow the tip of my pen with your eyes and eyes only. Not, I'm going to move it here and then move your eyes over here. Follow the tip of my pen with your eyes and eyes only. That's self-evident.
You think it's self-evident?
Yes. Simple instructions.
Okay. Simple instructions. How long, if you can tell me, is the lack of smooth pursuit test? What's the minimum amount of time that it can take to administer it?
16 seconds off the top of my head.
16 seconds. Is that correct?
Yes, sir.
Supposed to start with the subject's left eye. You always start with the left eye.
Yes, sir.
You go out, and it's supposed to take you 2 seconds to get out to maximum deviation. Come back in, another 2 seconds. Is that correct?
That's the prescribed amount of time.
And then, so 4 seconds per eye, 2 passes. Is that correct?
Yes, sir.
It's supposed to be smooth.
Yes, sir.
That's a simple instruction, isn't it?
Yes, sir.
That was something that you were simply instructed to do.
Yes, sir.
Is a 20% deviation in time significant?
So, again, if I was a robot, sure. I'm not a robot.
I understand that. Would you agree that it took you 13 seconds to complete the equal tracking in this?
I don't know how long it was. I'll take your word for it. I'm sure you know.
Okay.
13 seconds. So off by 3 seconds, so less than 1 second per check.
So off by 3 seconds. So we're talking about 19%. I'm sorry, I'll give you the extra one. 19%. Okay?
Yeah.
You don't think 19% substantial or significant?
That's less than a second deviation for each individual act.
Okay? If the client would have passed 80% of the clues, would you have passed him and said, yep, you're good to go? You substantially complied with it.
You know as well as I do, it's not pass or fail. There are certain things that we're looking for. And if they're present, and enough of them are present, I have to make the decision.
As a matter of fact, that decision to arrest, you are trained to arrest when? When do you make that decision to arrest?
Once phase 3 is completed.
Okay? So after all SFSTs have been done, correct?
You have phase 3, which encompasses the SFSTs and the PBT.
Okay? The PBT, but let me ask you, are you suggesting that you do not make the decision to arrest prior to obtaining the preliminary breath test?
I'm saying that my job is to acquire all the information I can.
Sure.
Once that point is passed, I then have to make a decision to arrest.
Okay. However, you're also trained that if you see 4 of 6 clues on the HGN, which is the very first standardized field sobriety test administered, what do you do?
4 clues.
You have 4 of 6 clues. 0 on everything else.
saying I conduct all the other tests,
Sure.
then I've got some other digging to do. And you're only considering phase 3 out of 3 phases. If I made it to that point where I conducted HGN testing, there's other things going on as well.
You're trained, however, that if you have 4 of 6 clues, you are to arrest.
Trained?
Mm-hmm.
I'm trained to consider the entire picture of what I have. Do they have, for this example here, even though I had 7 of 8 for the walk and turn test, Mr. Smith continued to look forward. That can impact how many clues you see. Maybe I would have seen all 8 if he was looking down his feet as the test is prescribed and as I instructed him. There's a whole what if scenario. I can't answer any hypotheticals because each arrest is different. I'm not trained to make an arrest just because I saw 4 of 6 clues. There's an entire picture there. Why didn't I observe walk and turn test?
You are trained that if a person exhibits 4 of 6 clues, that is indicative that their blood alcohol is more than 0.08, you said earlier. Is that correct?
Yes, there's an 88% likely.
Okay. By the way, have you ever actually read the California study?
Not in its entirety, no.
Okay. Have you ever gone through it as to the number of test subjects?
No.
You know that the vast majority of those test subjects were clearly impaired when they were tested.
Somewhere in the neighborhood of 70%?
Yeah.
I do remember hearing that.
70% of the, over 70% of the test subjects
Yes,
were impaired.
Yes, sir.
Okay. So if they would just arrested everybody, they would have been 70%, it would have been a 70% reliability on that test, right?
I don't know enough about it to answer. If it's, as you said, it sounds like you're more aware of that than I am.
So, if you believed he had a .08, you would have arrested him, is that correct?
Could you reword your question?
If you believed that he was at a .08, you would have arrested him, is that correct?
I mean, that belief is founded on all my observations. So if you, in other words, asked me if I would have arrested him based on all my observations, I clearly did.
Let's talk about the health analysis that you put him through. Because what you testified to was when you talked to him, he said he had a TBI that could cause headaches and other issues.
Yes.
What were those other issues that he indicated to you?
So he talked about some dizziness, I believe, or balance issues.
Unbalanced, it can cause me to be unbalanced. Is that correct?
He said, in a wishy-washy way, yes, he said that is something that he can deal with.
Okay.
I also asked him a follow-up question, was any of that troubling him that night? He said no.
Okay. You asked him if any of those from the TBI
Yes.
were troubling him.
Yes.
Okay. Later on, you asked him something else, and you didn't ask him if it was troubling him. You asked him if he had other physical issues.
His knees.
He said he had bad knees.
Yep.
You didn't ask him if those were troubling him.
Sure.
Correct?
Correct.
Did you take his bad knees into account when you scored the tests?
The individuals that I deal with on the roadside know their self better than I do. And this is all voluntary. I mean, if he doesn't want to, if he's not concerned enough about it to not want to do the test, I'm not either.
Now, wait. Do you believe that these individuals that you pull over and say, I'm going to do this to you, here's what I need you to do, I want you to do this, I want you to do this, and they're thinking, well, this is all voluntary, yeah, this is great, I'll do it.
I mean, I'm asking them. You can hear me say I'm asking you.
Okay. He's also obese, is that correct? He indicated his weight.
He did say that, yes.
More than 40 pounds overweight?
He indicated.
They couldn't do that before.
Don't make me do it.
Did you take that into consideration when you scored the test?
It was, he mentioned it. He made mention of it. There's their own physical appearance as well. At the same time, should I exclude every person who's 40 pounds overweight considered by the medical field to not do a leg stand test?
Let me ask the question again. Did you take that into consideration when you scored it?
Consideration of what way? Is it?
Your training says you're supposed to take it into consideration.
Okay, but
Did you take it into consideration?
considering his weight,
Yes.
sure, I mean, he's healthy enough to move lumber, stuff like that, get out, walk around without issue, is, you know, you can see on camera. I mean, while he's walking around his vehicle, he appears to be in good physical health.
He actually appears to be sober when he walks around his vehicle, doesn't he?
He doesn't stagger, stumble, anything like that, checks out his tucking.
Okay.
Doesn't mean he's not impaired.
It's when he's doing these balancing things on his bad knees and with his obesity that he has problems. Is that correct?
During the test is when it was most evident.
You indicated that during the walk and turn, he moved his feet. Is that correct?
Yes, sir.
And it's not just moving your feet. That's not the clue, is it?
If you look at the manual, what it says is record this clue if they move their feet from the starting position.
That's not what it says on your report, though, that you checked. You checked the...
I don't make those. That is a document made by the Highway Patrol that is not able to be edited. If someone did a poor job of wording it, that's on them.
And this is State's Exhibit D, and so the moves feet to keep balance while listening to instructions.
Yes.
Because you never say anything that he had to do it to keep his balance.
He told me that he understood that I did not want him to move.
I understand that. But you would agree that the video didn't comport. He didn't stumble and do any of this. He just came out of position.
Correct.
Which is his feet.
Which is an issue with the manual.
So on Exhibit D, and I understand you don't get it, you can't go in and white it out and change these things. You would agree that this, where he has checked moves feet to keep balance while listening to instructions, is not correct.
The wording of whoever made that is mistaken. I agree.
Okay. The
I could have just 1 second.
there was jumbling in him trying to get back in the starting position. He said, no, I had my other foot in front of the other. This whole left-right issue, right?
Yes, sir.
There's a way to demonstrate this for them, isn't there? As a matter of fact, you're supposed to demonstrate the starting position for them.
Sure.
You're supposed to instruct them, okay, what I'm going to do, you instructed them correctly. I want you to do this. I want you to place your left foot on that line. I want you to place your right foot in front of that left foot, arms down your side, stay in that position until I tell you to begin.
Yeah.
And then what are you supposed to do?
I demonstrate for him, which I did.
You did?
Yes. You'll hear me say, after I give him the instructions, if you start in a position like I am, then begin. Or something along those lines.
I'll literally say the word begin, okay? Yeah, while you're imagining, see that too? What I'm asking you to do, Brian? Yeah, right there. Last kitchen now, face my car. All right, what I'm asking you to do at this point, then just take a half step to your right. Okay. Perfect. What I'm asking you to do, Brian, is imagine a straight line. Yeah. Going from you to that number 2 that I have on my car there with a flashlight on. All right. Can you see that too? Yes, I can see it. What I'm asking you to do is to imagine a straight line going from you to that 2. Are you able to do that? Yeah. All right. I'll ask you to take your left foot over that line you're imagining. All right, left foot. Pretty good. Yep. And then right foot in front of left, touching on the toe. Yeah. Hands down to your side. Stay like that. Don't move till I said it again. You understand? What I'm asking you to do, Brian, is take a series of 9 toe-to-toe steps along that line you're imagining.
And so, is it your position that you demonstrated it right there?
Not right there, no. That's not what I'm saying.
Not just yet. I'll say the word begin. I'll literally say the word begin, okay? What I'm asking you to do is take a series of 9 toe-to-toe steps along that line you're imagining. Turn yourself around, take another 9 back. You understand so far? Yes, sir. I'm going to demonstrate for you. It's going to look like this.
Okay, so what you do is you say, okay, I'm going to demonstrate it for you, and then you start walking. Is that correct? I mean, obviously you get the starting position, but you don't say, okay, you're going to be here, now you're going to do this.
I'm literally mirroring them. He was standing in the starting position, I started in the starting position when I demonstrated.
I'm not disagreeing, you didn't, but you didn't say, hey, here's the position that you're going to maintain. And you're supposed to do that according to your instructions.
Once you stay like that till I tell you to begin, it means maintain.
Correct. And you're supposed to demonstrate it at that point so that they know the position that they are to maintain while you give them the rest of the instructions. Isn't that correct?
I don't recall if the manual says that that is the point at which you have to demonstrate.
Okay, you got the manual right there in front of you.
No, I don't. That's okay.
Oh, I'm sorry.
That's okay.
Did I steal it from you?
You're fine.
Okay. Section 8, page 42. Bottom for standardization of this test.
Administrative procedures, instructions, stage verbal instructions, assume no toe stance, arms outside, don't start until told. For under that it says for standardization, in the performance of this test, have the subject assume the heel-toe stance by giving the following verbal instructions accompanied by demonstrations.
Okay, and then it gives that initial stage, place your right, place your left foot on the line, right foot ahead of it. Next page, arms down sides, maintain this position until I've completed the instructions. Do not start to walk until told to do so. Do you understand it so far? And then you check for understanding, correct?
Yes, sir.
And you're supposed to accompany it with demonstrations, is that correct? Prior to then explaining the test requirements.
It doesn't indicate that in the breakdown.
I'm sorry? Okay, well then let's do this. Go to the next one. Go to the next section, tell me what that says.
Administrative procedure for a walking stage.
Explain the test requirements by giving the following instructions accompanied by demonstrations.
Yes.
Right?
Yes,
That's
sir.
a whole different demonstration phase.
I agree with that. Yes, sir.
Okay. You would agree you did not demonstrate the appropriate starting stance at the time you were supposed to do it. Is that, do you agree with that?
I agree with that, yeah.
Okay. So you indicated that upon completion of phase 3 is when you make the arrest and unarrest decision. Is that correct?
Yes.
And that is after personal contact, after the standardized field sobriety test, and you indicate after the preliminary breath test.
Yes, sir.
So,
It's all part of phase 3.
okay.
I don't arrest somebody and then ask them to give me a PPT. That's not the way.
Sure.
So,
Okay? So, you give him the administered preliminary breath test, but what do you do before you arrest him and read him his Marine rights?
I asked him how much alcohol he had actually had to drink that.
Yeah, you go further and start questioning more without Marine-izing him, don't you?
Correct.
You'd already administered PBT.
The reading wasn't back. It was still processing the sample before the sample registered.
None of which appears on video. Is that right?
I don't know if it shows up on video, but I can assure you, I asked him that question before that reading came back.
Did you know it was going to come back high, over .08?
In my experience, I believe that that was like that, yes. But I'm still in the process of acquiring all the information that I can at that time.
So I want to make let me make sure I understand this. I want the words in your mouth.
You have any firearms when you're in the vehicle? Okay. I was more than that, man. It's like, well, I'm going to
So you just administered all those.
go. Alright. Oh, yeah.
So, okay. So
Now, you're telling me at this point, you have not yet made the decision to arrest him at this point?
I didn't say that. My job is to acquire all the information I can. And once that is concluded, I make the decision to arrest.
Was he free to leave at this point?
Of course, not. It's traffic stop.
It's a mere traffic stop at this point.
It's, the scope of the traffic stop is still ongoing.
Okay.
If he refused a PBT, that's a different situation.
Okay. You would have arrested him.
Sure.
If he would have refused PBT, you were going to arrest him.
If I didn't have a PBT, in absence of a PBT, and everything else that I have, sure, I'll make that.
So, with or without the PBT, you knew you were going to arrest him.
If he didn't provide it, I will make that arrest. Yes, sir.
If I could have just one brief moment, Your Honor. Your Honor, I've got no further questions. I would object. I mean, he's already, as to State's Exhibit D, well, I think Mr. Hill can have an opportunity to rehabilitate it, I guess, so, if he wants to. We can address it later.
Any redirect?
No, but we are going to ask that D be admitted. I don't know why it wouldn't be.
Your Honor, he's already acknowledged that, no, it's absolutely incorrect. It's a form he did a couple days later that was not contemporaneous with his notes. It's just kind of a jot down, hey, here's what I thought happened, and we know for a fact at least one of them is incorrect.
Overrule, it'll be admitted. Anything else?
Nothing else, Your Honor. We rest.
Any evidence from the defendant?
No, Your Honor.
Case is submitted. Do you wish to submit anything further? Legal arguments?
Only if the court, I mean, I think we've had a number of suppression hearings in front of Your Honor. So if there's anything that the court particularly wants specifically briefed, we'd be more than happy to do that.
All right.
I don't want to be cumulative and just populate the court file.
I'll consider it submitted, and I'll review everything and issue a decision.
Thank you, Your Honor.
Thank you, Your Honor.
I need, you had one of the exhibits, Mr.
I apologize. I'm collaring the state, Your Honor. I thought I gave it back. Let me see here.
See, it was the manual, I believe.
I thought I gave it back to, I thought the trooper, did you have the trooper up there?
I gave her the
There we go.
manual
Okay.
cover and the 20.
Oh, here it is. Nope, that's my F.
That's the manual.
And then
You all should have A, B, C, D, E, and F up there.
and the jump drive, which we didn't have them marked on. I don't remember who I asked for it to do.
I've got 3G, A through G, is that correct?
That would be correct, Your Honor, I believe.
Yeah, do not have an F. What was F? I've got a G, but no F. Was it an F?
We have an F.
F was the
Breath test.
2255. Is that my F? Or? Yeah, that's my F. I can substitute my copy of that. But it's also in the
Oh, I've got
file.
it. Here it is.
Okay.
It was just how it worked. I have it. Okay. I think I've got everything, all these exhibits. Thank you. See you back at the jail.
No. He's gone to still, custom made, still.
Okay.
Still.
Okay, sounds good.
I believe the jail quit trying that. They said they wasted 4 cups and quit trying.
Okay. I'll just continue his arraignment then till Friday.
Yeah, no, that's fun.
I'll set him on then.
That's good.
So
State Law, Charles R. Hall, case number CRD 24-118.
I believe he's at Iron
He's at our municipal, yes.
Now, he had a clean drug screen.
He did have a clean drug screen, yes.
So I'll do him later. I'll, either later today before I leave court here, I can either do it from home on a laptop. So I won't continue him, I'll just, well, I'll continue it for today. I'll deal with him later. I'll take this file with me, call the other one.
State of Ohio versus Justin Bates, case number CRB 24-120.
Justin Bates, he is not given a urine screen. It's been several hours since he was ordered to do one, so I'm going to continue his arraignment. Well, actually, it'll be sentencing because he pled guilty.
Did you talk about Charles?
Paul,
Yeah.
he's at Iron Municipal.
Yeah, I know, so
What
then
do
when
they
my
want?
people called to do his assessment, they weren't able to because he was in court, so.
Okay. I wonder what's going on with him there. Probably warrant.
Well, they ordered him to OVP as well, but then we couldn't get the assessment because he was over there, so do you want me to just?
I'll just
have
order him
him?
to OVP and then I'll sentence him on Friday. 'Cause
Okay.
apparently they've done something with him, so.
Sentencing doesn't inpatient treatment.
Yeah, let's just, well, I haven't actually sentenced him, so we'll just make his bond 5,000 OR with release to OVP until Friday for sentencing. So that's the 15th, March 15th for sentencing.
Is that on Bates?
That's on Hall.
Oh, okay.
Now, Hall's the one you're talking about, right, Brianna?
Yes.
He had a clean screen.
I know, that's why I'm curious, because Hometown said after he was done at OVP to send him there, but if he had a clean screen,
Well, except for marijuana, tested for
why does he
THC.
need to come through OVP? He really wouldn't qualify except